Okay. Good afternoon, everyone. How are you? How's session going? All right. And I want to thank the committee and staff for being on time. And staff, thank you for putting everything together for us. So good afternoon and welcome to bill hearings for the House Health and Government Operations Committee. Your chairman, Jocelyn Peña-Melnick, joined on my left by my wonderful vice chair, Delegate Bonnie Collison, and the counsel for the committee, Ms. Lindsay Rowe, right here on my right. I kindly ask for your patience if we encounter any technical or streaming issues, because sometimes it happens, although it has not happened yet, so knock on wood. Watch it happen today, just kidding. Please set your electronic devices to vibrate. I'm actually doing that myself. Hopefully I won't embarrass myself. As a reminder, there's no food or drink allowed in the gallery. Our members can drink because we sit here for hours. So thank you for understanding that. For each bill, we're going to hear from the bill sponsor and the sponsor panel, followed by an all in-person witnesses. So it will be favorable with amendment, and unfavorable. And then all virtual witnesses the same, favorable with amendment, and unfavorable. The bill sponsor testimony is not limited, while all witnesses have 2 minutes to provide testimony. But while the bill sponsor is not limited, please don't abuse it, because I reserve the right to stop it if it's too long, because as session progresses, we're going to have very long days. So all I ask is to be courteous and considerate, and I know that everyone is. A timer is displayed on the screen, and a sound will play when your time has expired. Please adhere to our committee members, to our usual committee rules of 1 question and 1 answer. And please keep your questions brief so that you don't have long days. Members of the public will be able to view the live stream of this hearing on the Maryland General Assembly website and on the YouTube channel. And today we're going to hear the following bills in the following order. So we have the first bill, House Bill 235, then 227, 152, 289, 292, 232, 55, 133, and then the last bill of the day will be House Bill 91. I say that, but I also would like to have a little caveat that I am going to sometimes have to change it if our members have a hearing in another committee. If there's a witness that you have that you know is coming but got caught downstairs with security. So we're going to try our best to make sure that we are accommodating and respectful of everyone's time. We know it's not easy to come here to Annapolis, right? Finding the parking and everything else. So we will do our best to be accommodating. With that being said, I'd like to call House Bill 235, which is a departmental bill, Department of Natural Resources Pay for Success Contracts Procurement Exemption. If you will be so kind and identify yourself, and welcome to our committee. Having a hard time with that chair there? Doesn't want to be seated. Sit on it. Go ahead.
Hey, good afternoon, Chair Peña-Melnick and Vice Chair Collison and members of the committee. Thank you so much for having me today. My name is Josh Kurtz, and I'm the Secretary of the Department of Natural Resources. Joining me today is Sarah Lane, the Director of the Center for Policy Planning and Communication at the Department's Chesapeake and Coastal Services, and I'm here today testifying in support of House Bill 235. This is an important bill for the department as it provides a key procurement exemption for us as we look at pay for success contracts. In 2022, the Conservation Finance Act was passed, which gave us far more tools in the toolbox for restoration when it comes to stimulating private investment and working more with private sector. This bill provides a procurement exemption that allows us to do that more effectively. These contracts are really important for us as we move into the next stage of restoration of the Chesapeake Bay, because it sends a signal to the market that we value our ecosystem services, we value the benefits that come out of clean water, and we can actually, through this approach, put a monetary value on that. These contracts also provide us additional flexibility to seek multiple benefits. So it's not just paying for one outcome, but paying for multiple outcomes, whether that be habitat, cleaner water, equity, et cetera. And so these type of contracts are really important for us to allow us to be more effective. And what this exemption does is it provides a procurement exemption for the e-Maryland marketplace, which adds really a 3 to 6 month process to our existing process for these contracts. So if you are working with us, you're going to put in a pay for performance contract. You're then going to go through the procurement process, and you're going to add an additional 6 months to a year onto actually being able to move into that contract, start building. And what we found is that companies that are putting up private investment to do this, that additional time is actually, that time is money for them, right? Is keeping them from moving forward and participating in that. The great thing about this exemption too is it allows us to really holistically look at the potential of opportunities for restoration across the state, and ensure that we're investing our state dollars effectively and where we're going to get the best benefit for Marylanders. So just in conclusion, this is an important procurement exemption for us and will allow us to really step into the next generation of water quality improvement and do so in a much more modern and efficient way. With that in mind, I respectfully request a favorable report on HB 235, and I'm happy to answer any questions you may have.
Thank you. It's the first time you come to our committee.
Yes, ma'am.
Welcome to our committee.
Thank you.
Does anyone have questions? Everyone? Everyone? Yeah? That's what we do to people that come here for the first time. We're getting it slowly. Session is only the second week. It's the first bill hearing too, so that's great. Would you like to testify or?
No,
okay.
questions.
So seriously, are there any questions regarding this bill? Yes, Deli Kipke.
Thank you, Madam Chairman.
My pleasure.
Thank you for your testimony and welcome to the committee. What safeguards would be in place to ensure that contracts aren't awarded to companies that may not be deserving of the contract? You know, we're getting the best bang for our buck as stewards of the people's resources. Could you help the committee understand that?
Yeah.
Thank you.
Talk through the process. Yeah. You're on. Yeah.
Sorry. Cool. Break of the chair. So what this really, the exemption is just the extra procurement process. All of the contracts regarding of funding mechanisms still have to go through our request for proposal. We still have to review them for cost effectiveness, co-benefits. It just really is that extra e-marketplace. They're still having to provide us a request for proposal with all of that additional information and we review it for readiness to proceed, cost effectiveness, benefits, budget. So it goes through the exact same review process. Internally, we have now, it's just that extra step is removed.
Absolutely.
The e-Maryland marketplace, it's my understanding, is an opportunity to get broader attention to proposals. You know, is there still the same public display of what's available so that it's not just the insider contractors who might only be awarded?
Absolutely. The department runs all of our grants through something called Grants Gateway. And that process opens up late summer, early fall. It's open till December. So it would just be putting them through that same process that we already have and we've had that for about 5 years now. Yeah. So, yep. Yep.
Great questions. Thank you. Any other questions? Delegate Alston.
Thank you, Madam Chair. I'm just curious, what, if any, effect this will have on disadvantaged businesses and minority businesses?
Yeah. Thank you for that question. So currently the Conservation Finance Act lays out the contracts. Those are still required to meet all MBE, VSBE goals that are laid out by the state. So this change will have no bearing on us having those goals and meeting those goals.
Thank you. Delegate Shalega.
Thank you, Madam Chair.
My pleasure.
Good afternoon. Thanks for being here. How would this interact at all if so or not with single source contracting? Are we still going to be assured that there'll be multiple bids that will be considered, or could this lead to some kind of single source contracting?
No, we would still run everything through that Grants Gateway process, which would, regardless of funding mechanism. So these procurement contracts, as well as our grant agreements, and that there's no sole source associated with that Grants Gateway process.
Any other questions? Yes, Delegate Riley.
Thank you, Madam Chair. Yeah, I was just reading through this, I think the fiscal note, not the bill, the fiscal note. And it says, so I'm assuming that this bill is actually taking away the current process of to require a fund certification for the fiscal year in which the actual procurement is taking place. Is that, I mean, it's kind of like following up on Delegate Kipke's question. So this is eliminating the fund certification.
I'm not sure.
Under where it says background, it says, for instance, current procurement processes require a fund certification for the fiscal year in which a procurement is conducted. So is that certification going away? But yet what you're saying, your fund requirements are still there to make sure that the company is, you know, physically sound and.
Oh, yes, sorry. Yes, there's still, when we review proposals and all of that, yes, all of the company have to be in good standing, being registered with the state. That's already embedded in our grant agreement process. And that also transfers over to these contracts.
So this fund certification process. Is that what is, you know, taking a long time to actually procure?
We don't have,
Yeah, the thing that's been taking us is more that we're getting into the contract and then having to go through that second process with the same vendor. And so that delays them being able to actually use that private investment and put that project onto the ground so that we can then pay for the outcome once they've proven through their verification plan that it is in existence.
Thank you for the question, Delegate Riley. Any other questions or concerns? All right, seeing none, thank you so much for coming to our committee, and I hope you have a wonderful day.
Thank you, you
Okay?
too.
And this actually, if I may, Mr. Secretary, this bill will go to the Government Operations Subcommittee. So our bills, a lot of them, not all, but the majority are assigned to the subcommittees where the work is done. And you are allowed to come. So if you can make sure that when you see the schedule, make yourself available in case there are any further questions, please. Thank you very much. So this actually concludes, seeing all the questions, the bill hearing on House Bill 235. And to the members, thanks for the great questions. Now we have House Bill 227, which is the State Government Information Technology, Major Information Technology Development Projects. Is there anyone here for House Bill 227? Will you please come up? And when I call you, if you can come up with your panel, please. And good afternoon, Madam Secretary. How are you?
I was promised there would be cookies this time. Is
You know,
that-
we have, when you're done here, go to the committee. There's some, actually, I want to thank Delegate Shalika. She brought, Delegate Woods requested gluten-free chocolate cookie, and there's some, so.
So that
feel free to
happened?
Stop
Oh.
in for.
All right.
All right. Make sure Cassandra gives them to you.
Okay.
So go ahead.
Well, Madam Chair and Madam Vice Chair, thank you so much for hosting us. My name is Katie Savage. I'm the Secretary of the Department of Information Technology. At the table with me are Deputy Secretary and Chief Experience Officer Marcy Jacobs and Deputy Chief Experience Officer Ashley Lehman. And thank you for allowing me to testify in support of our departmental bill, HB 227, regarding major IT information technology development projects. The proposed changes in the bill are intended to enhance DOIT's ability to provide effective oversight and encourage the consistent use of IT best practices during the acronym you'll hear me say a lot, again, is major IT development projects, planning and implementation. So right now, MITDPs are anchored on a dollar amount as opposed to the criticality or importance of a business function. We also lack sufficient authority to enforce oversight of our findings. By expanding the definition of information technology, clearly defining MITDP criteria, ensuring that the Secretary has an adequate level of discretion when making MITDP determinations, and strengthening our ability to monitor and redirect funds, DO-IT can more faithfully assert that the state's valuable resources will be administered in a more effective and efficient manner. The proposed changes to the MITDP language as currently in statute include: one, expanding the definition of information technology to include the word networking and applications. This is clarifying language that aligns with what is in practice today. Two, more clearly defining the criteria which will be used by the secretary in determining whether or not to designate a project as an MITDP. As I mentioned, it's largely anchored on the amount of money being spent on a project right now, and we'd like to expand that definition. Three, providing the secretary adequate discretion in making MITDP determinations to ensure that if a project needs special attention because it is supporting a critical business function of the state, it has the proper oversight and funding it deserves. And this is, to me, especially important. Again, not to anchor on a dollar amount, but whether or not a project is of critical importance, it might be less than that and be a really critical pilot that we need to oversee to prevent shadow IT in the state. It might be more than that. And it might be a routine network upgrade. So we want more discretion about those projects that we turn a special attention to in terms of the oversight that our department provides. Four, requiring a unit of state government to provide information to the secretary, which confirms that the project meets the MITDP criteria, including if the unit of government has sufficient resources to support it throughout the development process. Five, the bill enhances the secretary's ability to monitor and control major IT MITDP fund expenditures. So there's a fund associated with those projects in order to increase compliance with statewide plans, policies, and standards. The legislative changes proposed here provide DO-IT the support it needs to enforce the policies and procedures it has put in place. The inability to consistently enforce these policies has resulted in project cost overruns, severe schedule delays, and limited visibility into agency product statuses. While legislation alone is not a substitute for effective agency project management, legislation may effectively serve to reinforce DO-IT's mandate as the state's MITDP oversight agency. We look forward to answering any questions you may have.
Thank you. Are you the only one testifying?
No, I think we'll just take
Okay.
questions.
Okay, wonderful. You know, I gave my daughter a book that says, I am enough.
I
So,
love that.
Anyway, Delegate Bandari.
Yeah, thank you, Madam Chair. We are talking about raising the threshold here, right? And expanding secretary's decision-making powers. How will the department ensure that this autonomy does not compromise project evaluation and oversight, thereby maintaining transparency and accountability in project selection and implementation?
Yeah, it's a great question. So to me, when I came in as secretary and looked at the current set of MITDPs, the projects that we're overseeing, I noticed on the list a number of projects which are routine upgrades, to Network Maryland, for example. But because they're above $1 million, they're receiving an oversight manager and sort of additional criteria that is redundant to what we already have on the team. Conversely, there are much smaller projects, and I'm mindful of moving into the space where we might do some AI projects. Those pilots are probably going to be under that threshold. But as the IT secretary, I absolutely want oversight into those projects. So it's really enhancing which projects we think deserve particular oversight and which projects are routine standard operating procedure and don't require that additional level of oversight.
Are there any other, Delegate Kipke?
Thank you, Madam Chairman. Similar to the last bill, what protects against, there was a scandal in the prior iteration of the department where someone in leadership was, I think, buying computers from their boyfriend, at much higher than market pricing. And, so these things happen, what protects against that type of thing in the process with this bill enacted?
Yeah, so that I think would already be part of the oversight process that we have in place. So for something like a hardware refresh, that's probably outside of this process anyway. But this is specifically referencing those projects like the upgrade of FEMIS, for example, or Compass, or any of these sort of statewide systems. So to your point, that's where we want for major projects, that are gonna be major investments. That's where we want to enhance the level of oversight. So we currently have a process in place where projects above a certain amount, or based on these criteria, you know, we could add additional, gives us more authority to add oversight to those projects. Receive an oversight manager. So they have someone specifically looking at their financials and reporting on a monthly basis. You know, where's the money being spent? Is it on budget, on time, looking at the contracts, and then reporting that. We also have the additional layer of OLA on top of that. So those projects have to actually receive 2 levels of scrutiny. And that's what we're really trying to enhance with this project, that those projects that, you know, to your point, might be really critical in terms of hardware refresh or something like that, receive almost additional scrutiny. But conversely, we're not putting oversight resources to things like Network Maryland, which are, you know, pretty standard in terms of the upgrades.
Thank you, Delegate Kipke. Delegate Kaiser.
Thank you, Madam Chair. I wanted to follow up on part of your answer to what one of Delegate Kipke's questions. I just
Sure.
want to make sure I heard you correctly or understanding it correctly. Are you talking about then projects, this is giving Do-It oversight over other agencies' approval of big projects?
So we already have that authority right now. But right now it's anchored to, is it $1 million or above? Which to me is really limiting in terms of what projects we should be overseeing. So if a project is doing, you know, if an agency is coming to me and saying, you know, because you know, it's a project above $1 million, for example, you know, we want to upgrade our server, which is pretty routine. You know, do we need an oversight manager and OLA and sort of all of the additional levels of scrutiny to that? Probably not. But there could be, to your point, a much smaller project that an agency is doing that if it comes through our intake process, which all IT projects do already right now, we want to say that actually, even though it's a small dollar amount, has widespread impact. Or it might be something that we're hearing another agency doing. So for example, you know, we've talked a lot about grants management systems. And if we're hearing sort of multiple agencies talking about that, we want to say, let's work together and bring this into our process so we're not doing duplicative efforts. So it gives us, they already come to us, I guess is my point, through the intake process. And we're just trying to make sure that we're assigning oversight to those projects that are really critical, regardless of dollar amount.
Thank you. Delegate Hill.
Thank you. And I just feel a little dense today, and I'm trying to get to this dollar piece because I thought what I heard, and thank you for being
Sure,
here and for all the
sure.
work. I thought what you were saying is that you want to make sure that critical projects, even at a small dollar
Yeah.
amount, get oversight.
Yeah.
But when I'm reading on page 3 and it says, major information technology development project means any information technology development project that meets one or more of the following criteria, unless the secretary determines that the project does not require the oversight, blah, blah, blah. The estimated total exceeds no more 1 million, but now it's a higher
It's
number.
a higher threshold.
So the smaller numbers will not get oversight if I'm reading this correctly.
So in the section above that, it states that unless and Marcy has it in front of me, unless the project does not require. So if it is a smaller dollar amount, that language, I think it's section 1, unless the secretary determines that the project does not require the oversight given to a major IT development project, and then it's the following criteria. So that does give us the ability, if we.
It has to be 5 million.
No, it doesn't. So that's what this designates. It lays it out in a way that if it's either these criteria, or if we say that it's a critical project. So the clause above it lays it out that.
We can talk. I just looks like a double negative, and I'm not sure. I'm not sure it does.
We struggled
Okay,
mightily
yeah.
with the language
Okay.
around this, but we believe it gets at that intent now, where if it's smaller, because you know we've talked on this committee before about AI pilots in particular, and I think that's a great example of something that's going to be almost certainly. And the other thing I will say is Marcy and Ashley and I talk about this quite a bit. I think we'd like to go in a direction where most projects start out a lot smaller and we do have more governance around them. I'm sort of concerned coming into the state and we have these $25 million in the first year, which to me, like, you shouldn't be giving that much money off the get-go. So this gives us the ability to say, even with smaller dollar amounts, and we want smaller dollar amounts, we want to be engaged to make sure they're getting off the right track, especially if it's something really critical. Yeah, yeah. We struggled with this as well, so would love to take that offline. Yeah.
And if I may, on page 4 of the fiscal note, the last paragraph says, DO-IT also notes that the Office of Legislative Audits has recently issued multiple findings that relate to the effectiveness of DO-IT's oversight over the state IT projects. By granting the Secretary of IT additional authority and more clearly defining DO-IT's oversight role, the bill allows DO-IT to compel agencies to more closely adhere to DO-IT's advice and MITDP policies, thereby addressing the audit findings. Can you elaborate a little more on the audit finding, please?
Sure. I'm really glad you raised this because it's a really important piece of this. So in the OLA findings that came back to me, my first year as secretary, they came back as findings around project management. And to the letter of the law before this change, we really don't have oversight around anything more than sort of fiscal responsibility, fiduciary responsibility. So, before I came in, really the oversight managers were largely focused on budget and schedule of the contractor. And OLA, I think correctly said, we as the IT organization for the state, we'd love for you to be more engaged in guiding the projects and project management. And I agree with that. So with my team here, we will be working to be more engaged on the project management. And that includes, when an agency comes to us and says, we plan to kick off this project, do they have the IT staff that can appropriately plan for it, allocate resources for it, sustain it after the fact? Do they have a plan in place for user testing, for design? So what this also does, to that point, what this strengthens is moving from a place of just fiduciary oversight to project oversight, which is in line with what OLA would like us to do. It's a shift for the department, but I think an important one that OLA raised, and I agree with.
Are there any questions? Seeing none, I want to thank you for your patience as we ask the questions. Again, for everyone that is sitting here, this bill will be assigned to government operations. I like to make yourself or your team someone available. If you're not able to come, I understand you have to be in 100 places, but have an expert in the room so they can address the questions of my members.
Absolutely.
Thank you very much.
Okay.
Thank you.
Thank you.
And I think that actually concludes the bill hearing. House Bill 227. And thank you very much. Don't forget your cookie.
Okay.
Next, we have House Bill 152, Delegate Boyce. Thank you so much to the delegates that have been patiently waiting. Delegate Pruski, I see you. And this is House Bill 152, Department of Environment Study on Death Care and Funeral Practices. And we did pass this bill last year unanimously. Good afternoon.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the Health Government Operations Committee. For the record, I'm Delegate Regina T. Boyce, here presenting HB 152, Study on Death Care and Funeral Practice. And I again want to thank this committee for passing this bill last session and ensuring MDE could meet the requirements of the study while maintaining the goal of the bill. While death is a sensitive topic, acknowledging the potential fear and contemplating our remains of our loved ones is essentially to recognize that a thoughtful consideration of how we manage these remains is crucial, especially when it comes to environmental and public health implications. Though research nationally and internationally, an examination into the implication of these practices remains under-researched in Maryland. The bill requires, as you remember, the Department of the Environment in collaboration with the Maryland Department of Health and the Maryland Department of Labor to conduct a comprehensive study on the environmental and public health impacts of death care and funeral practices in the state, and allows the department to consult with outside organizations and institutions for the study. Conventional death practices like embalming, traditional burial, and cremation are common yet extremely harmful. It's estimated that 800 1,000 gallons of formaldehyde are placed in the ground each year due to conventional burials. This method consumes significant resources like land, copper, wood, and more, promoting the need for a thoughtful reassessment of its environmental impacts. Cremation is known to be better, more environmentally friendly option than conventional burial. The practice is on the rise across the country. The cost is 10 times less than burial, but the process still releases carbon monoxide, sulfur dioxide, and the other heavy metals into the air. I can go on about alkaline hydrolysis that turns the body into a sterile effluent, or natural burial, which is gaining popularity in Maryland. And we can't forget about natural organic reduction, which is a form of composting the body. Regardless of the method, we know it has an impact, and we must study how different methods impact our state. To give an example, for instance, taking into consideration the number of active and inactive cemeteries in the state and how much land cemeteries consume, how much more land do we have to continue to bury our loved ones? Cremation, again, is on the rise. We have roughly about 55 facilities in the state. What is the current impact on air quality, given newer versus older technologies, and how much more should we consider or not? These are just a few of the types of the questions I hope the study can answer, plus more. What will be best for Maryland's land, air, water, and future? I again ask this committee for their considerable consideration. Thank you.
You're welcome. Are there any questions for Delegate Boyce? Delegate Taveras.
Thank you. All right, let me hear you better. Okay, so just thank you for putting this together. I think that this is a very interesting bill. I'm gonna speak, I guess, through my office mate, Delegate Woods, who is not here. She did put in a bill on composting a funeral. And I do believe that it did not pass. I'm not sure why. I think it was kind of like a new concept for folks, and I think people were not. And as somebody who was dealing with a funeral a couple of months ago, this was something that was very attractive for my family. However, we were not allowed to consider it. What is it that we are looking to kind of change and shift all types of funerals to those that are just more healthier for the environment?
Thank you,
altogether?
Delegate. This is just a study. It enables the department to look at what are just the health and so it doesn't, I should be clear, it doesn't certify any programs that are or services that may not be certifiable yet in Maryland. It just looks at the impacts. We're having, as many may or may not know, for instance, cremation is on a rise, and funeral homes, for instance, in Baltimore City, are allowed to extend their services to cremation, and it's becoming a concern for some residents. I think all forms are important, but the question then becomes, what are the impacts, especially as across the country, and even in Maryland, these sort of practices are on the rise. And again, what are the current impacts given the different types? We don't have any more land to bury folks, right? We don't have, we do have, for instance, cremation as an option, but then people have questions about that. So what I'm hoping, if anything, this study does is inform individuals about what they would like to do with their loved ones and themselves, and hopefully less about saying one is better than the other, because I think what we'll see through the process is they all have an impact one way or the other.
Delegate Kaiser.
Thank you, Madam Chair. Thank you, Delegate Boyce. Given that both of our bills passed the House last year and not the Senate, and I am reintroducing mine, would you say that the two bills are a complement to each other?
Absolutely.
Thank you.
Delegate Johnson.
Thank you, Madam Chair, and thank you, Delegate Boyce, for bringing this bill again to us this year. My question is, will this study look at the declining number of burials and how that will affect the maintenance of the graveyards that we already have?
You know, I don't know, but that's an excellent question for it to for consideration. Again, land, air, water. Again, I know, for instance, some people are not taking the burial route. For instance, folks, some articles that are reading, one of the reasons why, for instance, cremation is so popular is because people don't ship bodies anymore across the country. If I'm in California, I live in Maryland, I die in California, somebody's going to get me cremated in California if that's what they believe, right? And so, or not necessarily have me buried. And in some cases, to your point, and back in the day, if you died in California, you're from Maryland, you end up being buried in California. So that's a great question, and I'm hoping this committee amended this bill greatly so that it can meet the overall goal, but also meet a fiscal obligation. So while it does mention all these different types in the bill, casket, mausoleum will do their impacts, and I'm sure hopefully those impacts will be again on land, air, and water. But I don't know if it's going to look at that. I did have someone ask me about whether or not this bill would also look at the financial impact that burial has or any type of death care practice has on an individual, and which ones potentially could be cost prohibitive. So the bill is I should say is not very specific. It's more broad, and hopefully that is something that could be determined.
You're welcome. See no other question. Thank you very much, Delegate Boyce, for
Thank
your
you so
testimony
much.
today. And again, when the bill is assigned, if you can come to the subcommittee. This actually will conclude the bill hearing on
Thank you, ma'am.
House Bill 152. Delegate Kerr, Delegate Kerr, let me call Delegate Pruski for a second, okay? Thank you so much for being so kind. Delegate Pruski, you have been sitting there patiently, so I'm going to call you next, and that is House Bill 55. So you can go back to your committee. Good afternoon. How are you?
Good, I'm great. Thank you, Madam Chair, Madam Vice Chair, members of the committee. Good afternoon. Today I'm here to testify on behalf of House Bill 55, Delegate Andrew Pruski. Over the past several months, you've heard a renewed focus from Secretary Woods and the governor on militaries and their families. This bill is personal to me. I actually had a uncle who served in Vietnam that we had to care for when I was younger, and certainly it was a family effort. And that's what the state is trying to do. We're trying to create a commission for veterans and military families to provide a more coordinated effort and a strategic plan along with some performance indicators. This commission has a shared vision in bringing together these stakeholders to make a better place for veterans and their families. Maryland is known for supporting veterans, but we could always do better. Representatives from the Senate, House, and numerous advocates would serve on this commission. As you see in the fiscal note, there is a minor cost, but I think it's well worth it. All too often, we have good work to serve veterans, but there's a lack of coordination. This commission and this bill is to bring stakeholders together to better serve and to make legislative, budgetary, and policy recommendations. As I stated earlier, the commission is a one-time cost. Remaining funds would be sent back if the commission work is complete. The fundings of the commission will be shared with the governor and the General Assembly by December 1st, 2024. Today, there is an advocate that you'll hear from, but I certainly hope that you would consider this bill a favorable report, and I respectfully ask that you support it. Thank you so much.
Thank you for your testimony, Mr. May. Good afternoon. You don't have to touch it. It comes.
I got it.
I know you feel like you want to, right? We all do. Go ahead.
Good afternoon, Madam Chair.
Good afternoon.
And members of the committee. My name is John May. I'm an Air Force Chief Master Sergeant retired and Vice President of the Maryland Military Coalition. The coalition is a nonprofit, all-volunteer veterans organization, veterans advocacy organization of 21 veterans organizations who in turn serve over 150,000 Maryland uniformed services, men and women, their families, and survivors. The coalition urges a favorable report by the committee on HB 55. This bill will establish a commission on veterans and military families, which will lead to the development of a strategic plan to make Maryland the best state for veterans and military families. Although many notable legislative and administrative proposals have been identified to improve the lives of Maryland veterans and families, these ideas are considered in isolation without a comprehensive analysis. The commission would be able to develop a statewide plan to guide legislation and budgetary decisions. We're also impressed by and fully endorse the diversity of voices and representation required in the commission's membership. And we're gratified to see the inclusion of a representative of the Federal Reserve, a significant part of the military force structure that all too often is not represented. Establishing this commission directly supports and enhances the Moore administration's Year of the Military Family Initiative. The coalition and its 21 member veteran organizations strongly support HB 55, and we urge a favorable report. Thank you.
Thank you, sir, for making the time to come. We're going to go now, so that we know the process, to the virtual witness. After the virtual witness testimony, actually, that's a favorable with amendment. So let me just wait. Since you're favorable, let's open it up for questions. Any questions? Which one? Oh. Yeah. All right. No questions? I do have a question, if I may. Did you see, maybe not, the Maryland Hospital Association letter? In there, they have a request for an amendment. Are you okay with that?
Yeah, I don't have an issue. Again, there's many stakeholders. We're going to meet with them to make
Yeah.
sure. So we want to make sure we're as inclusive as possible.
Yeah, they said we recommend adding a representative with experience in workforce development
Absolutely.
in order to help service people reduce the barrier to education and careers, especially careers in high need like healthcare. So it makes sense.
Absolutely.
All right, wonderful. Thank you. Let's just go to Mr. Christopher Arnold.
Good afternoon, Madam Chair.
Good
members of the committee.
afternoon.
It's
How are
great to be
you?
back For HGO. I was in Richmond this morning and Annapolis this afternoon, here on behalf of the Undersecretary of Defense for Personnel and Readiness. Investing in the well-being of military members, our families, and veterans builds strong, livable communities and enhances military mission readiness. House Bill 55 gets us off to a great start in achieving the ambitious goal to make 2024 the year of the military family in Maryland. Secretary Woods, Delegate Pruski, and all the co-sponsors are making the pie bigger, as you're not only addressing the specific needs of military families, but also enhancing Maryland's overall attractiveness as a place to live and work, thereby benefiting the entire community. The Department of Defense has identified military community representation on state boards and councils as a top state policy priority. And one of the Secretary of Defense's 3 strategic priorities is to succeed through teamwork. The policies reflected in this bill align well with these priorities by establishing the Maryland Commission on Veterans and Military Families, including military voices such as a military spouse and the Office of Military and Federal Affairs and the Maryland Military Installation Council on pertinent policy bodies enables states to consider the unique needs and priorities of military service members and their families across critical issue areas such as education, healthcare, housing, employment, childcare, nutrition, and other key quality of life areas that benefit service member and family readiness, retention, recruiting, and resiliency, which are all considerations as part of our strategic basing process. In addition, the Defense State Liaison Office stands ready to support the Commission in the development of its recommendations to strengthen Maryland as both a great place for military families to live and an ideal home for military installations. We'd especially like to thank the bill sponsor, Delegate Pruski, and the Maryland House Veterans Caucus for all your tireless advocacy.
Thank you for your testimony, and it was my mistake. You are favorable. The next witness is favorable with amendment. Are there any questions for this witness? I want to say thank you on behalf of the committee for your testimony. We really appreciate it. Delegate Pruski, thank you very much. And this would again go to subcommittee. Make yourself available. And sir, thank you for coming today. We now have favorable with amendment, Joshua John. Is Joshua John here? Yes. And what is your name?
Morgan Mills, our intern signed us up to testify, so I guess he used his name.
Yeah, she didn't sign you up, but you know, we don't usually do it because we have to make sure the record is perfect, but I'm going to allow you to come and give it, okay?
I appreciate that. Thank you kindly, Madam Chair.
And don't be hard on the intern when you go back,
Oh, of
okay?
course
Things
not.
happen.
Never that.
We
I
were
was
all
an
there
intern
once in a lifetime. Go ahead.
Well, thank you so much. Good afternoon, Madam Chair, Madam Vice Chair, and distinguished members of the Health and Government Operations Committee. My name is Morgan Mills, here today on behalf of NAMI Maryland. We represent a statewide network of over 58,000 individuals and families, and we provide education, support, and advocacy for persons with mental illness, their families, and the wider community. I'll keep this testimony brief because this is a great bill, and I want to thank Delegate Pruski for bringing this forward. We support the bill entirely. NAMI Maryland would just like to be added to the commission. We offer free programming, NAMI Homefront, which is a resource created specifically for service members and veterans that deal with mental illness, as well as their families. NAMI Maryland was actually chosen to pilot that resource because of the immense success we have reaching military families across the state. Addressing veterans' mental health is really key to ensuring a great quality of life. We realize that a representative that advocates on behalf of military families is already included in the bill language, but we don't want to take a slot away from other organizations advocating for veterans in other spaces. And for that reason, we ask that NAMI Maryland be specifically included as a member of this commission. Thank you.
Thank you. Are there any questions for this witness? Seeing none, thank you very much for your testimony and for the work you do in Maryland. This actually concludes the bill hearing on House Bill 55. You have a great day. Next, Delegate Kerr, who was very patient and gracious. Will you come, please, and give testimony on actually both bills? House Bill 289, when we're done with that, we'll go on to 292 as well. If you could bring your panel for the first bill, please. Thank you. Good afternoon.
Good afternoon, Madam Chair, Madam Vice Chair, fellow members of Health and Government Operations. I'm Delegate Ken Kerr. I'm here today to present House Bill 289, State Contracts Prohibited Provisions. This is a bill that concerns an aspect of state procurement. Under current law, an officer or agent of the state charged with specific responsibilities may not make or participate in making for any purpose a contract that purports to bind the state to pay an amount unless the money has been appropriated for that purpose and remains unspent, to create a deficiency, or to incur a liability or spend money in excess of the applicable appropriation. So what we're talking about today is the concept of indemnity. So in very simple terms, indemnity is like a promise to cover or compensate someone for loss or damages. It's a way to protect parties from financial harm if things go wrong. So in a formal setting like a contract, the indemnity clauses are written as a promise that define who is responsible for specific types of losses or liabilities. So an example would be if a group gets together to rent a beach house. And you sign the contract for the beach house, but you have a party and your friend breaks a window. You are indemnified to pay the damages incurred by your friend, so that the landlord who rented it to you expects you to make him whole. So the property owner is the one protected by the indemnity clause, and the person renting is the one providing the indemnity, the promise to make things right. So indemnity is a clause that helps ensure that if unexpected issues arise during the rental period, the landlord won't bear the full financial burden. So simply enough, however, under current law, the state, and as you will hear from members of the panel today, is prohibited from fulfilling this aspect of a contract if it creates a deficiency, if it involves funds that have not or already been appropriated, or the liability is in excess of the appropriation. So in real day-to-day fulfillment, the $6 billion in contracts Maryland enters into each year, this can manifest in a multitude of ways. And now I'd like you to hear from the members of my sponsor panel who will give you some more examples and explain why this bill is necessary.
All right, who would like to go next, please?
I'll go ahead. Thank you, Madam Chair, Madam Vice Chair, members of the committee. Thanks for the opportunity. My name is Jen Gartner. I'm a native Marylander, and I'm the Deputy General Counsel at the University of Maryland College Park. I've been a practicing government contracts attorney for over 20 years, and for the past 10, I have been supporting the university's research and land grant mission. I negotiate contracts with university partners and vendors on a daily basis. I'm privileged to work with a group of dedicated public servants. They work hard to negotiate agreements that support our students, our faculty, and our staff engaged in groundbreaking work on behalf of the state and our nation. Too often, they get bogged down for weeks or months trying to explain to our vendors and partners why the university cannot accept certain boilerplate contract terms like indemnification, like California governing law, like waivers of jury trial, or binding arbitration in the European Union. Many vendors ask our personnel to simply point to a statute that says we cannot accept these clauses. This bill would give us that simple step, and that simple step would save an enormous amount of time and needless frustration. It would also create clarity for our vendors so they know what to expect when doing business with the university and other state agencies. The bill would also solve the problem of click-through agreements where you have to click I agree or I accept to use a piece of software or a website. Often it's impossible to negotiate those click-through agreements, so our personnel have to click I accept in order to carry out their state duties. But click-through agreements can impose substantial liability upon the state and violate existing state law. This bill will streamline the contracting process for all Maryland agencies, not just the universities, significantly reduce personnel time required to negotiate contracts, reduce frustration for our vendors and our faculty members and other state personnel, and protect the state by reducing the risk of liability and litigation. Teddy Roosevelt said, "The best prize that life offers is the chance to work hard at work worth doing." Supporting the university and state is work worth doing, and this bill will help us do that work more effectively and efficiently. Thank you, Delegate Kerr, for sponsoring this bill. I respectfully urge a favorable report on House Bill 289.
Thank you. Next, please.
Yes, my name is Arthur Rose. I'm University Counsel of the University of Maryland, Baltimore, sister institution with Gardner's Institution. Just like to add a few points to what she has already laid out. The importance of this bill would greatly increase the efficiency and the effectiveness of the contracts that our institution and in fact, all state agencies enter into routinely. We spend, and our contracting staff spend months sometimes negotiating over clauses that we simply can't agree to, but we can't get other parties to understand why we can't agree to. This bill would give us a very quick and effective way to shortcut that process, get contracts executed. In my institution's case, we have the University of Maryland School of Medicine as part of the University of Maryland, Baltimore. We engage in hundreds of clinical trials every year to the tune of hundreds of millions of dollars. We receive sponsored research funding for critical medical research, also to the tune of many hundreds of millions of dollars. Oftentimes, those clinical trials are delayed for months because of dickering over these legal clauses, which we lawyers know we can't agree to, but we have to educate a lawyer in Delaware, a lawyer in California, a lawyer in Texas. Have to go up sometimes through many layers of the legal team till we get a lawyer to convince that our position is justified under Maryland law. This statute would give us a very quick and easy method to point to, short circuit all of those arguments. There are many provisions of this statute which we think would be very, very effective and helpful. It's patterned after similar legislation in Ohio. Matter of fact, the language is very similar. We adapted it to Maryland specifically. It has our experience and our knowledge is that in Ohio, it has greatly increased the effectiveness of their contracting procedures, has enhanced state government, and has enhanced the state university institutions.
Wow, perfect timing. All right, we will now open it up for questions. I have Delegate Kaiser.
Thank you, Madam Chair. As I was listening and and understanding your indemnity example, Delegate Kerr, I was a little confused when I just look at the beginning of the fiscal note. If the contract includes a prohibited provision, I was just trying to understand, how can a contract ever include a prohibited provision? And if that happens, why isn't there already something in place to make it null and void in some way? So I'm just trying to understand that broader question.
Can one of you give a good example?
I'll give an example. Routinely, it's boilerplate contracting 101 that, let's say, for instance, a sponsor of a research agreement says, we'll give you $100 million to do your medical research, but you have to indemnify us for any liability that might arise out of that contract. We respond and say, can't do that. Well, why can't you do it? Well, I can point you to an advice of counsel from the Attorney General's office, which goes through a long and a complicated legal analysis of why in the Maryland Constitution it says this. There's an opinion of Attorney General saying that it really means that. It takes a lot of education. So it is prohibited under Maryland law, and it's in that sense, this is a restatement of existing law. However, it doesn't say it clearly in Maryland law.
Thank you. Any other questions? We have Delegate Hill.
And thank you, Delegate Kerr, and thank you all for being here. I get the point. We're trying to make sure that our contracts make sense and we don't screw the Maryland taxpayer. I get that. What I'd like to understand is if the boilerplate contracts are including these indemnification clauses, and now we're more clearly not going to be allowed to go along with them, how are we signing contracts? Because my experience is boilerplate contracts are take them or leave them contracts. And how do we do that timely?
You want me to go with that? Okay, so that's an excellent question. We are often able to come to creative workaround solutions so that we can write in, additions to the boilerplate contract. However, our contracting personnel can't do that. So as Mr. Rose was saying, it takes months often to get to an attorney at our partner organization to explain to them why it is that we cannot accept their boilerplate contracts. These boilerplates are intended for commercial use, not for state business. Once we're able to get in touch with an attorney, we're usually able to come to terms and sign a contract that comports with Maryland law, but that isn't always the case. And there are times when we have, for instance, these clinical trials or the semester is about to start and vendors will wait to the last minute thinking they can kind of strong arm us into doing that. Our contracting personnel are very aware of the scope of their authority and they don't want to overstep it, but they do want to see the university and the state succeed. And when they're asked to point to a statute, this bill right here would give them that statute to point to that says, well, we can't indemnify you. We can't accept California governing law. We can't waive our jury trial. We can't appoint somebody other than the attorney general to litigate a case. So if they were able to simply point to that, a lot of times the vendor, the contracting personnel at the vendor, not the attorneys, can look at it and say, oh, I see the support for your position. I understand. We can move forward.
Seeing no, yes.
And Delegate Kerr, I think this is you. We've done some work in the last year or so to also require that our contracts have liquidated provisions in it, because again, when the contractor doesn't follow through, we're often found just paying them the money and they didn't provide the service. So that this does not affect this directly, I would assume, but it does strengthen our contracting ability to make sure that we get the services that we need and we're not paying for services that we don't get.
Yeah, go ahead. The bill actually does address the fact that we, the state, would be able to get another contractor to complete those services and then bill the original contractor. This is something that the federal government has in a lot of its contracts, so we have adapted it from federal law.
We have Delegate Collison, followed by Delegate Alston, followed by Delegate Shalega.
Thank you, Madam Chair. And thank you for being here. I think I understand what's desired. I guess I'm wondering if that will limit the potential contractors, or if you've had that experience, or I just heard you, Ms. Gardner, say it generally doesn't, and that you were usually able to work around it. But I guess I just want to reaffirm that.
My expectation is that it would not limit the potential contractors. They have to understand that this is a provision of Maryland law as it is. And I don't know why this would dissuade a contractor who wants to do business with the state, or wants to sponsor research in the state, or wants to have sell goods and services to the state.
May I add one?
Actually, we don't, but you may be able to. In the next question is a follow-up by Delegate Collison.
So we have a testimony from the Associated Builders and Contractors, and I think it goes to what I was thinking. Their concerns is essentially that contractors unaware of heightened liabilities may persist in bidding in signing contracts, and then they would be in a position of liability that they weren't expecting. So I guess that it could escalate insurance expenses, potentially limiting bonding access, given the state-centric tilt in the agreement. So thoughts, responses to that? I mean, again, it's really about unintended consequences potentially.
This is your opportunity now.
Thank you. Yes, we have had vendors actually specifically ask for a law like this so that the landscape is clear to them when they negotiate with the state. So this is actually part of the reason why we suggested this bill, was that vendors have requested it for clarity. Like Mr. Rosa, I don't anticipate that it would drive vendors away, because typically we do come to terms with them. It just takes 8 or 9 months, and everybody would prefer to come to terms in a couple of weeks and get those contracts signed.
I do have Delegate Alston, followed by Delegate Shalega.
Thank you, Madam Chair. I have some concerns with removing the indemnification clause for all of these contracts that the state would enter, because I'm not sure that it's going to be fair to some of the parties that are going to be waiving that right. And there's been no negotiation. And so this is coming to our subcommittee. I'm sure I'll have more opportunities to explore this, but I'm really mostly concerned about how do you see this affecting conflicts issues? If you have a federal issue of law and it goes to federal court, is this even going to stand up? And are you also mandating that all contracts use Maryland as the venue or as the jurisdiction and pick a venue in Maryland? Is that also one of the changes?
Who's the best person to answer?
So the Attorney General's advice is that we must follow Maryland law because we are a state of Maryland agency. So we either select Maryland law or we remain silent, or with the federal government, we can of course accept federal law. I have negotiated with the federal government on these clauses, and they have actually understood and accepted the reason why we cannot indemnify, which is actually already set forth in state law. State personnel who sign a contract that create an unfunded liability, and we have court cases that state indemnification creates for the state an unfunded liability, are actually subject to individual civil and even criminal penalties. So this would not be saying that the state won't live up to its guarantees or accept liability for its responsibilities for things that it has done. But what it says is that we will not pay for unknown and unquantifiable liability down the line that we have no control over. So this really is just a clear restatement of existing state law.
You have a follow-up, Delegate Alston.
A bunch, but I'll wait till subcommittee.
Okay. So I would say make yourself available for subcommittee. We have next Delegate Shalega, followed by Delegate Morgan.
Thank you, Madam Chair. Thank you for being here. So I am on the subcommittee as well, so look forward to working with you. But you said that the state will not accept unknown liability for things down the road. Are you now expecting business to accept those liabilities?
No, we expect that both the state and our partner organizations will be responsible for our own actions. What we cannot do is be responsible for the actions of a third party who we don't control. And that is where the indemnification problem comes in, which is my understanding is that's why it's already prohibited by state law, because we don't control it.
Is this then, sounds like setting up a boilerplate contract for the state of Maryland? Is that what you're trying to do here, so that you don't end up with all versions of it?
Who's the best person?
No, I don't think we're trying to set up a boilerplate contract with the state. No, not at all. What we're trying to do is establish a clear statement of state law in a way that today is the law, but is not so clearly stated, so that we can respond when we receive contracts from third parties with these clauses, and we can say, I'm sorry, we cannot accept it because of this legislation.
Delegate Morgan.
Madam Chair, you've said it a couple times, and I think a lot of my colleagues might have missed it. I just want to give you another opportunity to elaborate. Basically, when it comes down to it, this bill is just codifying and clarifying existing practices that are already in effect. Isn't that so?
Yes, that is correct. We operate under the advice of the Attorney General, and as Mr. Rose explained, we can point to the laws that are currently on the book, but because they are not clear, we often have to educate the other attorneys, and that assumes that we can get in touch with an attorney. But yes, you are correct. This would simply restate in a clear way existing state laws.
Thank you. Great. And when you get a, isn't that so? Yes, it's acceptable. But that's good. Delegate White.
Yes, thank you, Madam Chair, and thank you so much for your testimony. I believe it was mentioned on this panel that there was similar language in Ohio. And so given some of the concerns as well as some of the unintended consequences that have been elevated here, can you expound upon what exactly happened and how things played out in Ohio so we might have a sense of what we could potentially expect? I know it may not necessarily be the same bill, but can you expound upon what does implementation look like in Ohio and how they may have been able to mitigate some of these unintended consequences?
Go ahead, you spoke with them.
Okay, yeah, so I actually spoke with colleagues in Ohio and in Georgia, which is another state with a law on the books, and they've said that it has streamlined their process and drastically reduced frustration, not just for state contracting personnel and the people who are doing the work, but also for the state's partner organizations, because it now lets them understand exactly what the state can and cannot accept without having to put in months of negotiating time and finding an attorney to interpret the laws. This is just a nice, clear statement.
You have a follow-up?
Yeah. Go ahead, Madam Chair. And have we seen any unintended consequences that has limited the number of vendors or potential or businesses entering into the contract? Has it stifled that process?
No, not to my knowledge.
My pleasure. Any other questions? Seeing none, I want to be a fly on the wall for this discussion in subcommittee. Anyway, thank you so much for your testimony. We really appreciate it. This will actually conclude the bill hearing on House Bill 289. Thank you very much for coming, and thank you for the work you do for the state of Maryland. Next, we have Delegate Kerr. Do not go away. We have House Bill 292. And we have State Procurement, Maryland State Board of Contract Appeals, attorneys' fees. The question is, do I want to? Good afternoon. You can bring your panel. So Delegate Kerr, if you can get us started.
Hi, good to meet you. Two witnesses signed up. That's me. You probably won't be able to testify since you're not signed up. Yes, it didn't. We'll see what the chairman says. Good afternoon, Madam Chairman.
Good afternoon, Delegate.
Just a little sidebar here.
So we're on House Bill 292.
Yes, House Bill 292 is state procurement, Maryland State Board of Contract Appeals attorneys' fees. And in competitive sports, on-field officials and governing bodies are committed to fairness. A coin toss determines first possession. Players switch sides on the field or the court at predetermined periods in the match to ensure that both sides are facing the exact same playing conditions. There are established rules to which all players must adhere and referees to enforce them. And often there's an opportunity to challenge a questionable ruling and have a third party arbitrate or decide. A well-known phrase grew out of competitive sports that I'm sure we've all used. It's a level playing field. Leveling the playing field is a metaphorical expression that means to create fair and equal conditions for competition or interaction, ensuring that all parties have an equal chance or opportunity. So the first recorded use of this outside of sports was in the Tyrone Daily Herald in January 1977, where John Bolger, who was a lobbyist for the U.S. Bankers Association, is quoted as saying, "Our philosophy is that we have no problem competing with the Mutual Savings Bank if we start from a level playing field." So major aspects of level playing field are fair competition, equal opportunities, eliminating unfair advantages or disadvantages, promoting equality, and ensuring a fair process. So overall, the goal of a level playing field is to create an environment where competition or interaction is fair. Success is determined by merit rather than external factors that may give an unfair advantage to certain groups or individuals. So House Bill 292 is about leveling the playing field. Every Maryland department, agency, division, board, commission, administration, unit, or authority has assigned to it one or more attorneys from the Attorney General's office. These are paid for by the state of Maryland. The offices of the Attorney General refers to itself as the largest law firm in the state of Maryland and describes itself as the legal advisor to virtually every agency in the state government. So these state agencies enter into thousands of contracts each year, totaling over $6 billion. And each year, many of these contracts come into appeals ranging from disputes over terms, allegations of impropriety, regulatory compliance issues, disagreements over scope of charges. So if a vendor believes that it has been unfairly treated, it can file a dispute. If it's still unresolved, they can go before the Board of Contract Appeals. So the Maryland State Board of Contract Appeals adjudicates bid and contract disputes. So as I mentioned earlier, each of these state agencies has legal representation. So having a team of lawyers to represent them comes at no expense to the agency. A vendor who goes before the Maryland State Board of Contract Appeals is required to have representation. So after looking into this a little bit, I found that there's no such thing as an average cost of appeal. But a litigant should expect to pay no less than $15,000 unless it's very simple and limited in scope. Complex cases can go up to $20,000 or even $35,000. And so now for the level playing field, a vendor who believes it has a legitimate dispute does not have an attorney on staff. The agency does. So we learned in 1 Samuel chapter 17, David, against all odds, defeated Goliath.
Only Natio. Go ahead.
But what makes that a great story is because it was so unexpected. It never happens. In life, it rarely turns out that way. So House Bill 292 attempts to at least give the Davids a slingshot.
Very good.
Thank you. Now, I would like you to hear from my panel, and
What order will you like? Who will go next?
well, we do have an issue to deal with. We have
Okay.
two witnesses who signed up. The third believes he signed up, but he's not. I don't believe he's on the list. Will you allow him to testify?
So I'm gonna do this today just because he's right here in front of me, but for all of us, myself included, let's make sure that people signed up because we can't do that because of the record and it's just not feasible. But this is the beginning and we have a little energy, so go ahead. I'll speak for
And a little
myself.
extra
Go ahead.
time. And
Go
he
ahead.
promises not to go over his 2 minutes.
Okay, great.
Okay, let's start with Michael Miller.
Oh,
All right, thank you, Delegate. Thank you, Madam Chair, members of the committee. Thanks for having me here today to speak in favor of House Bill 292. My daily job is representing vendors with the state of Maryland, contractors who routinely deal with state agencies. And quite often it's before the Maryland State Board of Contract Appeals, or the MSBCA, as we call it in shorthand.
State your name for the record.
Yes, I'm sorry. My name is Michael Miller. I'm sorry. So let me start by saying that this bill will lead to lower bid and proposal costs for the state of Maryland over the long run. As I said, I represent vendors on a regular basis. I speak to them quite often about their bid and proposal process. And I know that many of them routinely add into their bid and proposal prices a contingency amount, a small amount in their estimation, because they know that it can be very expensive if they have a dispute over the formation of the contract or eventually a contract claim before the MSBCA. If they are given the opportunity to recover their claims or protest costs, including attorney's fees, which the attorney's fees are the largest chunk of those costs, they're going to lower the amount that they have to build into their bid and proposal prices to the state. The problem right now is that even if there's an obvious violation of procurement law that they see during the process, whether it's during the formation process or in the handling of their claim, they're reluctant to go through with the process of asserting their rights all the way to the MSBCA because they know how much it's going to cost. As Delegate Kerr mentioned, thousands upon thousands of dollars in legal costs because the state gets free legal advice. They get free legal services, and the state doesn't mind running up your legal costs in front of the MSBCA in order to win the case. I'm here today because I believe in the Maryland competitive procurement system. It was created by the General Assembly in 1980. And when it was initially passed, and it's still in the law today in the state finance procurement article, there were, I'm sorry. Let me just leave it with this. It's about fairness and equity for everyone, including in particular, the small businesses and MBEs. That's why this bill is important.
Thank you. Next, please. And the time, please adhere to the time. Thank you very much.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Michael Arrington. My company is Capital Connections, and I'm here today in support of HB 292. And I'd like to thank you, Delegate Kerr, for sponsoring this legislation. I'll be very, very quick. The current law excludes recovery for attorney's fees when a prospective bidder proves that the agency has violated the procurement laws. That's an unfair and burdensome provision of the current law and warrants being changed in our view. And this is not a novel idea. Federal government procurement laws do provide for the recovery of those attorney's fees. Second point I'd like to make is the bill provides for recovery of attorney's fees and claims arising out of a procurement for contracts other than construction. There's a current carve out that allows for recovery of attorney's fees when it relates to construction companies. That I believe is unfair and undermines the General Assembly's policy of fair and equitable treatment of all people who are doing business with the state of Maryland. So for those reasons and the reasons that Delegate Kerr has mentioned and my colleagues here have mentioned, I'm here to urge a favorable report on HB 292. Thank you.
Thank you for your testimony. Next, sir.
Madam Chairwoman, thank you for allowing me to speak. My name is Robert DeShiel. I'm a member of the Maryland Procurement Improvement Council. I've been practicing procurement law now for going on 51 years. My daughter, who practiced with me for 10 or 15 years, was recently appointed as a member of the Maryland Board of Contract Appeals, which left me in somewhat of a lurch because I don't have anybody to give stuff to anymore. I'm here really to tell you that I need help. I mean, I don't have, my firm has never had the resources of some of the other firms. So for the last 50 years, I've had to make do, as my grandmother said. I've had to work twice as hard, two or three times as hard to represent clients who had valid and legitimate claims as bigger companies who had the resources to hire attorneys. More importantly, I've had to turn away firms who I knew had meritorious claims because they simply couldn't afford even what I consider to be my modest attorney's fees. And even after, and this bill is even narrower than that. This is not a bill saying to make lawyers rich. This is a bill that you only can get recovery if you win. And I can tell you after 50 years that that is rare. before the Maryland Board of Contract Appeals for whatever reason. So we support it, and I'm here not for me, because as I say, I've been at this 51 years. I'm here for Solomon and Genesis, my grandchildren. Thank you so much.
Thank you for your service.
Thank you.
Are there any questions for this panel? I see Delegate Kaiser followed by Delegate Chisholm, followed by Delegate Hill.
Thank you, Madam Chair. Thank you, Delegate Kerr, for this bill. And while I was enjoying the cookies made by Delegate Shalega, your sports analogy drew me back in, and I was so grateful to be here. Of course, for your David and Goliath analogy as well. But just very quickly, I really just wanted to say that. But the DGS legislation letter of information, which is opposition, but they don't say that. They reference the fact that they think that passage of the bill would likely result in increased protests, appeals, and contract claims due to the perception that bidders or offerers can recover the filing cost and attorney fees. And I would just like to give you or your panel an opportunity to address that concern.
We're limited to one response. Does anyone have?
Who's the best person to answer that?
Well, the answer is it's true, but it's necessary, because only by protest and claims does the system improve. You have to, and my problem is my clients can't afford it right now because they can't afford to pay me. And I'm, as I say, I'm just tired. So the answer is true, but it's necessary because as a result, you have more competition. As a result, you have firms across the landscape, small, medium, and large, who can compete. And as a result, you get the state employees to do a better job.
Thank you. Delegate Chisholm, followed by Delegate Hill.
Thank you, Madam Chair. It does strike me, in civil court, if you win, you can petition the court to have your attorney's fees paid. I am no friend of attorney's fees, I promise you that. But I do have a specific question. It struck me, you said something about that there's a carve out for construction. Can you explain or give me the details on that?
Go ahead, Mike.
Thank you, Delegate Chisholm. Yeah, the way the statute is currently written, attorney's fees may only be awarded in cases concerning construction claims. So there's already a contract in place, and the contract goes to there's a contract claim filed, and you prevail before the MSBCA, then you can ask for your attorney's fees, reasonable attorney's fees. That the carve out is for all contracts other than construction contracts. And as we know, the state of Maryland every year has more and more in the way of services contracts, like IT contracts, security, you name it. And on those contracts that are not construction, you already at the current time, you cannot recover attorney's fees in regards to those claims, even if you prevail.
We're leveling the playing field. We're treating everybody.
Yes,
absolutely. We're not playing different sports. In other words, we're playing one sport on one field for all contracts.
My pleasure. Delegate Hill.
Thank you, Madam Chair, and thank you, Delegate Kerr and gentlemen, for being here. Trying to get those 5 smooth stones to slay the giant. Currently, the board, formerly the Board of Contract Appeals, and for some reason being changed to the Appeals Board, may provide folks who succeed in their appeals with everything but reasonable attorney's fees. Mr. Deloach, is that your name? DeShield, thank you. You said that it's rare that the appeals board fines for the petitioner. And
that's right.
Right. And so my question is, in those rare instances, do we have any data about how often when the petitioner wins, does the appeals board give them any fees at all? I mean, are they stingy since it's a may and not a shall, and people are completely out of pocket?
Who's the best person?
I'm going to defer to Mr. Miller. He probably has more data because he's been there more times than I have.
Thank you, Delegate Hill. The fiscal note itself even mentions that over the past 5 years, there's only been 1 successful claim and 5 successful protests. 5 successful protests represent just over 6% successful of all protests filed in the last 5 years. That's actually far lower than the GAO rate in the federal realm of roughly 17.5%. It's one per year, and then petitioning for the costs is usually, that doesn't even happen, because the proposal or the protest costs themselves, excluding the attorney's fees, are quite minuscule, right? So most protestors who have prevailed at the MSBCA do not even ask for those costs. It's not worth it.
Okay, I'm sorry. I just want to be clear. So what you're saying, and I missed it in the fiscal note, what you're saying is, unlike other court cases where if the petitioner prevails without asking an additional thing, or even in Judge Judy's court, right, they can say, and if I'm right, I want the following costs. You're saying it's 2 steps now, that I first have to prevail. And instead of them making a decision on their May that you get it, I then have to file an additional request to showing my cost and asking for that to be covered?
Yes, I think when at least when I draft an appeal, I ask for whatever reasonable relief the board would give me. But typically, you would not seek the costs of filing your protest and filing the appeal. There was a case, I think the fiscal note mentions it, in the one claim that was successful. It was actually a claim that was brought by University of Maryland Global Campus against what had been a client of mine. And eventually another attorney finished the case, but they were not able to recover their attorney's fees in that matter. Yeah. Oh, yeah. And I think they weren't able to recover those either. It's just, it's quite rare, actually. It's quite rare. Mm-hmm.
Thank you. Seeing no other questions, I do have one. Delegate Kerr, did you see the letter from the Maryland Department of General Services and the letter from the Maryland Department of Transportation, where it says that this bill will result in increased protests, appeals, and contract claims due to perception that you can now recover filing costs and attorney fees? How would you like to address that, or who's the best person to address that?
I was in conversation with DGS and MDOT prior to the bill hearing. And then we've agreed to continue to speak as the bill goes to subcommittee.
Fantastic. Thank you. There are no other questions. And before I terminate the hearing, sir, will you be so kind, because you were not registered, will you go to the HGO? Delegate Kirk can take you and make sure that they have your name, who you work for, and how we contact you. That we must have that for the record.
I certainly will.
Thank you very much. And actually, this concludes the bill hearing on House Bill 292. Thank you for your time. Thank you for your service to Maryland.
Thank you.
My pleasure. Now we're going to go on to House Bill 232, which is Physicians and Allied Health Professions Reorganization and Revisions. Marie Grant, I know I saw you earlier. There you go. And if you can bring your panel, that would be great. Thank you so much. And for the committee, we only have 2 more bills after this. Good afternoon. Who would like to get started?
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Madeline Del Greco. I'm a health policy analyst with the Maryland Board of Physicians. The Maryland Board of Physicians is in support of House Bill 232, Physicians and Allied Health Professions Reorganization and Revisions. First, I would like to note that we are aware of some minor typographical errors that will require amendment to correct, but we have no substantial amendments. You have my written testimony where I go into detail about how this bill stems from the Board of Physicians 2020 Sunset Report recommendations. So for the sake of time, I won't touch on that now. However, it is important to note that House Bill 232 makes no substantial changes to statute, will not alter current board practices, nor will it change licensure requirements for any practitioner regulated by the board. Rather, it is only a restructuring bill that streamlines and cleans up the Maryland Medical Practice Act. As the Maryland Medical Practice Act is currently organized, all health occupations have some requirements that are consistent, and those requirements are repeated in each health occupation section. So this includes stuff like the criminal history record check requirement and the change of address notification requirements. This bill would
Can you be so kind and put the microphone a little closer to you? Thank you very much.
This bill would move those common provisions to one centralized general provision section. In addition, House Bill 232 standardizes terms and eliminates redundant or outdated language throughout the act. The Maryland Board of Physicians anticipates that this bill will make a significant positive impact on the accessibility for board staff, regulated healthcare practitioners, and legislators alike to navigate the Maryland Medical Practice Act, and are in support of moving House Bill 232 forward. Thank you for your consideration.
Thank you for your work. Who's next?
Good afternoon, Matt Dudzik, Manager of Policy and Legislation for the Maryland Board of Physicians. I really don't have anything to add to that, so I'm just here to answer any questions.
Well, we like the Me Too, Marie.
Thanks, Madam Chair. Marie Grant on behalf of the Maryland Department of Health. Really here to just say me too. We're very supportive of this departmental bill and urge a favorable report with those technical amendments offered by the board.
Wonderful. Are there any questions? Delegate Shalega.
Thank you, Madam Chair. Thank you all for being here. I did get somebody write to me, and she indicated, and I know you don't have the bill in front of you, on page 6, she believes that there'll be less reporting. This provision 5715. It looks like it's just changing the provision from one statute to another, but maybe what I'll do is send you this letter and then you can take a look at their specific concerns and respond to me.
Absolutely. Please send that over. The bill was intended to not change any reporting requirements. There is a substantial amount of moving around. We had to strike a lot of statutes and move them to other areas, but certainly it was not the intention to remove or reduce any reporting requirements. So if you send that, we are happy to take a look at that and make sure that that's the case.
Will you be so kind and make sure to include counsel when you do that?
Absolutely.
And definitely the delegate that asked the question. Thank you so much. Are there any other questions? Seeing none, thank you so much for your testimony. That was so quick, right? This actually concludes the testimony on House Bill 232. Next, we have House Bill 133. Is a delegate here? House Bill 133, Commission to Study African American Civil War Soldiers in Maryland. Why don't we wait for him? Let's go to the next bill, which is House Bill 91. Good Foley, good afternoon. How are you?
Fine, thank you, Madam Chair. And
do you have a panel that you like to bring up?
Yeah,
with you?
there are a couple of people who
Why
are
don't
going
you
to
do that,
testify.
please?
So if you want to come up, one of them might be virtual. Yeah. Okay.
We have two virtual witnesses.
Okay, great. Thank you.
Mhm.
Good afternoon, everyone. Thank you, Madam Chair. And thank you, members of the Health and Government Operations Committee. It's wonderful to be here. For the record, I'm Delegate Linda Foley, and I'm introducing HB 91, Fossil Fuel Powered Lawn and Garden Care Equipment State Purchase, Use and Contracts Prohibition. So for starters, let me note that there are several sponsor amendments that have already been submitted to this bill. And I'll go over those as part of my testimony. The first one is we're proposing to move the bill from the Department of the Environment to State Finance and Procurement, where it more properly belongs. So I'd like to make a brief case for the bill and what it tries to accomplish. And then I'll go into ongoing efforts to reduce the fiscal note and mitigate the costs associated with the bill. We're all familiar with the Climate Solutions Now Act, which we passed in 2022. And it sets out rather ambitious goals for Maryland to reduce fossil fuel emissions throughout the state. The law requires us to reduce fossil fuel emissions by 60% by January 1, 2031, and get to net zero emissions by 2045. Last fall, the Maryland Department of Environment issued a climate pathways report that identified areas and practices that could get us to those goals, excuse me. One area highlighted by the pathways report was reduction in the use of fossil fuel powered non-road engines and equipment. HB 91 is a step toward cleaning up that sector of our state government. I'll let the supporters of this bill highlight the environmental benefits of phasing out gasoline-powered lawn and garden two-stroke engine-powered equipment. And I will recommend to you that you read the report submitted by US PIRG as part of the written testimony that makes the case for eradication of all these dirty, noisy, gasoline-driven devices and equipment. But HB 91 is less drastic than eradication. It's a phase-in bill, requiring only that state agencies purchase electric rather than gas-powered lawn and garden equipment when that equipment is up to be replaced. Not all at once, but as you replace the equipment, you replace it with electric-powered equipment. It doesn't require the immediate purchase of an all-electric fleet of non-road equipment. And even at that, replacement is not mandated if electric equipment isn't adequate to do the job or unavailable for purchase. There is also a requirement that state contractors use greener lawn and garden equipment, and I'll talk more about that in a minute. All that said, the fiscal note on this bill shocked me. And in its pre-filed form, unamended form, it is unacceptable. The governor's office, and indeed the agencies affected by this bill, all support the intent and goal of this bill, that is getting to a clean energy fleet of lawn and garden equipment. The fiscal note does point out that once we get there, our operating costs are likely to go down because we won't be spending money on gasoline. Also, the upfront costs are also likely to go down as we go forward. I've already collaborated extensively with the governor's office and agencies all across state government to submit several sponsored amendments that I believe will drastically reduce the fiscal impact of this bill. First, we have an amendment that will delete the requirement that state contractors immediately begin to use electric equipment or begin next year. Instead, we push that back to toward the Climate Solutions Now goal of 2031. We push that back to January 1, 2030. And I'm willing to work further with state agencies to make the contractor language even less fiscally impactful. We are further clarifying with another amendment that only work performed for the state and not on all of the contractors' projects are affected by this bill. We are also proposing amendments that would narrow the scope of equipment covered by the bill. This amendment would remove large, heavy-duty mowers and the like from requirements of the bill, limiting it to handheld or small lawn and garden equipment. That's a significant change in the costs that would be incurred by the state to swap out that equipment. We are exempting trail management and vegetation activities in backcountry area of state parks, forests, and wildlife areas where electric infrastructure is non-existent, because that is another significant cost that would be incurred by DNR to erect electric infrastructure in those far-flung areas. I have been in contact with the fiscal note writer who, even today, as well as last week, who assured me that the changes encompassed by the amendments will have an effect on the fiscal impact of this bill. He has agreed to review the changes in the next few days encompassed in the amendments and check with the agencies affected to gauge how the fiscal impact will be reduced, and he'll communicate those new findings. As I indicated, I've been working with the governor's office to put this bill in a posture so it can pass without having a detrimental effect on our fiscal situation. All the agencies affected by the bill and the governors are working with us to achieve the results intended by this legislation. I'm confident we can get there with the committee's help and a little patience. and a lot of work on my part and the agency's part, and they've all pledged to do that. And I urge a favorable report on HB 91 once it's amended. As the PERG report indicates, local and state governments, along with major institutions, should lead by example by using electric equipment for their landscaping needs. We have to get to these climate goals, and we have to start taking steps to get there and make real progress, or we will never reach them. Thank you for your time and consideration, and I'm happy to answer any questions.
Thank you. Next, we have Ms. Jennifer, Ms. Ryan.
Thank you, Madam Chairwoman and committee. I'm delighted to be here. Before I make my testimony on this, I'd like to ask and comment that I'm disappointed that there are no live captions on the screens in this room, and that it would really be helpful to people with disabilities to have the instant captioning for live hearings. I am here to express my strong support for House Bill 91, sponsored by Delegate Foley, which you just heard about. As you know, it prohibits the state of Maryland from purchasing, contracting, or
May
using.
I stop you for 1 second?
Yes, ma'am.
There is the caption on the YouTube channel. Okay, you don't see it here? But
No,
we do
ma'am.
have it on
We
the
do not
YouTube
see it
channel.
in the room, and I
No,
tried to
you-
access it on the YouTube, and it was not working.
Well, the YouTube channel has it, and we'll look into it, but they do have it.
Thank you, ma'am.
Okay?
It still would be nice for those in the room to have it on the screen, and I believe that's what the Americans with Disabilities Act would require. So I'll just comment on that. I'm sorry.
You have 1 minute and 19 seconds.
Okay, so I will just summarize, since I've used up my time, that as a concerned citizen, a member of Maryland's Climate Commission, I'm very, very concerned about the damage that these equipments are causing. I'm also a resident of Annapolis, and our neighborhood has had 3 significant damaging floods in just the last 6 weeks, that the fiscal cost of this bill is far less than what our state is going to be spending after we have continued climate disasters. I have provided written testimony in advance. I'm happy to answer any questions, but I strongly urge you not to water down the bill for fiscal reasons, because I think we will pay much more money later in climate damage if we don't get on top of taking care of fossil fuels as soon as possible. Thank you very much for your time and consideration.
Thank you. Are there any questions for these 2 witnesses? Delegate Shalega, followed by Delegate Chisholm.
Thank you, Madam Chair. Thank you for being here. I'm glad to hear that you're going to amend this bill because yes, what was it, $4.5 million fiscal note is clearly unaffordable. So you mentioned that handheld and small garden equipment. What does that mean?
Well, if you, Delegate, if you look at the bill, what we're doing is we are, there's a list in the bill. It's on page 2. Lines 4 through 7. And what we're doing is we're amending the bill to, instead of saying include, to just say that that's what it covers, except we're indicating that it's not the large, big lawn mowers. Okay.
It's still leaf blowers, and
Yes.
there's a testimony, and I don't know if you've been able to access the testimony. There's quite a bit of unfavorable testimony, but this one in particular says, to put it in perspective, pricing a gas-powered backpack blower is $550. The price for an equivalent battery backpack blower is $1,300, obviously more than double. And then the battery kit alone is $400. So, we're talking 1,700, and I know, being in construction, those batteries do not have a super long battery life. Having to replace those batteries is difficult. So I think it still may be cost prohibited, but with regards to batteries, do you have any plan for battery disposal? Because we'll have a lot of batteries if your bill passes.
Delegate, this bill does not address that. I agree with you that we do need a plan for battery disposal. We also have passed legislation to completely electrify the state fleet of on-road vehicles. Those batteries are also going to need attention. So this bill does not address that. But I do think it's an area that does need to be looked at.
Delegate Chisholm, followed by Delegate Morgan.
Thank you, Madam Chair. And, you know, you bring up costs, and I'm just going to make a statement real quick on the lithium batteries. That, you know, that we recycle less than 2% of them worldwide now. So it is a problem. And when we talk about damage being done, well, lithium is very, very damaging to the environment just to mine. We mine out of a couple different places. One would be Thacker Pass, which is 18,000 square miles out in Nevada. Part of it's supposed, I'm just saying, they say is on a tribal ground, which is causing a lot of environmentalists to even look at that one. But outside of there, we get lithium from China. We get lithium from Afghanistan, which is completely controlled now by the Taliban. So we have to ask ourselves, at what point does the cost, are we concerned? And I know your bill is very specific too, but we also have to look at the cost to human life where we're mining out of Africa and places like China where child labor is still prevalent. It's not even hidden anymore. So what precautions are you taking to make sure that if we're replacing all the fossil fuel powered equipment with lithium batteries, that we make sure we do it in a safe way, a way that can be recycled, so we're not hurting the environment even further there?
Thank you, Delegate, for that question. Again, I do think that we need to be cognizant of lithium batteries and lithium. But first of all, I think some of this equipment, depending upon where it's used, doesn't necessarily have to be battery powered. It just to be electric. And second of all, all of those issues that you raise are not addressed by this bill. What this bill does is we have passed already into law the Climate Solutions Now Act, which requires us to reduce fossil fuel emissions. This area has been an area that's been identified as an area where we have to do some work and reducing our fossil fuel emissions. And obviously, you know, the state is one piece of that. The other piece of that is a consumer piece, right? In the consumer market, that's a much bigger lift than this. But we have to begin somewhere. These goals for fossil fuel reductions are coming up. We passed legislation, that's law now, that we have to meet these goals. And my point is that, you know, we need to move toward clean powered equipment on road and off road in the state of Maryland. That's a place to start. So that's what this bill does. I think the issues around batteries and battery disposal all are valid issues, but that's not what this bill addresses.
You have a follow-up? Okay.
Put it front and center. And when you say that we don't always need batteries, well, we can't just plug into electric. And I think this idea that electric is just clean is false. And we have to look at the whole picture of things. If we want everything to be electric, well, where are we getting our electric from? We're still getting our electric from many different sources. And a lot of times those sources can be more environmentally damaging than what we're currently doing.
Yeah.
Isn't that so?
Yeah. You said, isn't that so? I see what you did there. So, yeah, yes, Delegate, I understand your point, but again, I'm focused on, this bill is focused on meeting our fossil fuel reductions, our fossil fuel emission reductions. That's what we have in law. That's what this bill is focused on.
All right. No questions? Okay, Delegate Morgan, and then I saw Delegate Johnson. Oh, and Delegate Hutchinson. Okay.
Thank you, Madam Chair. But thank you for the bill. I appreciate the presentation and everything. You mentioned the consumer piece, just so personal note, I switched everything over to electric a few years ago. As a homeowner, it actually works pretty well.
Good.
For what I had to do. I have some doubts whether that could actually work in a commercial setting or by the state. But my question for you is, we're often talking about, you mentioned a few times during your testimony here, getting to the climate goal. And I know the state has identified a 60% reduction in greenhouse emissions by 2031. That's the bill that you mentioned, the Climate Solution Act now. My question for you is, if this bill passed, as you said, amended, how much of that 60% would we chip away with?
Well,
is it 0, 1, like somewhere?
It's hard to say, because if you read the fiscal note, one of the things the fiscal note identifies is it's kind of hard to get your hands around that. Like, it depends on how quickly things get swapped out. But in the climate solutions now, the climate pathways report, this was, I believe, it was a small percentage, but it was somewhere in the neighborhood of 5 to 10%, I believe. The whole universe of this non-road equipment. Granted, on-road cars and trucks are, are the biggest polluters, right? And then, we have things like, coal-fired plants. And I mean, there's a lot being spewed into our atmosphere. Cement making is another really dirty, polluting activity that was cited by the Pathways report. But my thinking on this bill was that this is starting small, but you see how difficult. I mean, it is difficult. It's not easy. And if we're going to move to these bigger areas, like, for example, electrification of buildings, which is not covered by this bill, which is something that's being discussed now as part of meeting the climate solution goals, we're really talking about taking much bigger steps. So this is not a big percentage, but it is a first step, as I said in my testimony. And I believe that the state needs to lead by example. And this is a good way to start. And maybe more people will be inspired to do what you did. More Marylanders move to all electric equipment and, in their own yards.
You have a follow-up? Go ahead.
Real quick. I mean, yeah, I was inspired to do it because I just thought it might be easier on me. Nobody forced me to do it.
Good.
I know that several counties have also done something similar like this. Is Moco one of the counties that did this? And how has that policy?
So Montgomery County only banned the retail sale and use of leaf blowers, not any other lawn and garden equipment. The reason I went to lawn and garden equipment in this bill is because that was the language that's in here was the language cited in the Pathways report. Okay. The Montgomery County bill was just passed. It has not, the use ban, the retail ban is in effect. The use ban has not gone into effect yet because on a consumer level, there is a debate about whether it makes sense to do incentives or bans. Okay, so you could do carrot or stick. So I don't know, Madam Chair, how much you want me to go into this, but Colorado, for example, gives tax incentives to consumers, much like the car incentive to trade in leaf blowers in that case. California has also passed a ban on gasoline-powered lawn equipment. That goes into effect this year. So that's across the state, not just the state itself. So there are some smaller jurisdictions that have done some things. DC banned leaf blowers. Leaf blowers is the first thing because they're very noisy also. So DC has banned leaf blowers, for example. There's some other smaller jurisdictions around the state that have banned leaf blowers, but there's no statewide ban on lawn equipment like this.
Mm-hmm. Right. My pleasure. Delegate Johnson, followed by Delegate Hutchinson.
Thank you, Madam Chair, and thank you for the bill and coming and answering our questions. Mine is not about battery disposal. My question is about, getting the work done, making sure that we continue to get the work done. So, and I'm hearing a little bit of conflicting testimony because I have a weed eater that is a 1993 and a riding mower that's a 98. And I heard you say that they would be required as they wore out to then replace them with electric, but I'm seeing from Maryland Green Industry Council and in the bill that beginning January 1, 2025, it prohibits the state from entering into or renewing a contract under which the contractor or a subcontractor employed by the contractor uses fossil fuel powered lawn and garden equipment. And I also, from Maryland Arborists Association, says our industry is already facing labor shortages. This bill will generate the need for more labor to complete the same job. So on the question of the replacement and being able to enter a contract with the state, if you still have some gas powered equipment that has not worn out yet, if you could answer that for me, is that part of your amendments you're
Yes.
looking at? Okay.
Yes, Delegate, the amendment says, pushes that date out a lot further to January 1, 2030. And as I indicated in my testimony, you know, if we have to move that date, the contractor piece is the hard piece, right? If we have to move that date again, you know, we will. But that's why I'm working with the agencies to try to figure that out. I sat down with the governor's office and we discussed that piece. I discussed that piece with the highway department, and they felt the MDOT felt, which is a huge, that's where most of the contracts are, I think, maybe DNR as well. But they felt that that January 1, 2030 date was a date that they could deal with the contractors, because this industry is moving rapidly. Okay. The delegate over here asked about jurisdictions like, you know, around the state. I know back to Montgomery County, one thing in Montgomery County that has happened is the Park and Planning Commission has gone all electric on everything. And they did that rather quickly, and they're actually pretty happy with the equipment they have. So that's a small example, and I'm not saying that it applies across the state. I'm just saying that, you know, this market is changing pretty rapidly because the demand for electric equipment is really pretty high. And you asked another part of your question, Delegate, and I'm sorry, I forgot what it was.
I did. It was from the Maryland Arborists Association. It says their industry also is facing labor shortages, and this bill will generate the need for more labor to complete the same jobs.
Yeah, well, I can't speak to the amount of labor it'll take to complete the jobs. I don't know that. I know that let me just say this, that again, I think this equipment is getting more and more efficient. And so that may be true today. It may not be. I'm hoping that it's not true in 2030, that we get more and more efficient with it. I think changing over our economy and our the way we work, the services we provide in Maryland, changing over our economy for the reliance that we've had on fossil fuel is difficult. It's very difficult, and we have to make some changes to move there. I think in the short term, the upfront costs might be more, but in the long term, you're going to save a lot of money on fuel. And, you know, I don't know if that offsets the additional labor. It may very well offset, depending upon the price of gasoline, for example, because, you know, going forward, you won't need to spend money on that. And the repair costs are much less on electric equipment. So, you know, a lot of this is a little fuzzy, I agree, but we also have to take steps to get to where we need to get. So thank you for the question, Delegate.
My pleasure. Delegate Hutchinson.
Thank you, Madam Chair. Delegate Foley, I applaud you for your passion about this. I actually first heard about this bill because I did attend the 2-day webinar that the Sierra Club and Shore Rivers held a couple weekends ago about every climate and environment bill. And I remember you presenting this bill. And I also remember you made a comment, and I think you alluded to today, you want to start at the state level, but eventually you really want this to be a consumer level bill. So I need point of clarification, because last year I remember you being here and you were just going after our leaf blowers. And I remember Delegate Martinez asking this question. I think it's been asked, but I need a clarification.
Sure.
I'm a private landscaper and I am a subcontractor with the state of Maryland. If I am working on a state job, do I need to abide to this? And if I'm not working on a state project, do I need to abide this? So I'm most concerned about my private landscapers, and I sort of have a follow-up to depending upon your response here.
So in the first instance, not now, but when that contract is renewed on January 1, 2030 or later, yes, you would have to migrate to electric. And the question about do I have to use it on all of my work jobs? The answer is no, just on the state jobs.
Follow up on that. I don't have the actual statistics on this, but I did ask my landscaper who does an awful lot of work in Dorchester County about this bill and the eventual, all of them having to move over to pure electric. And he sort of chuckled and he said, do they realize that I'm going to have a gas powered generator on my trailer all day long so that I can charge up my batteries while I'm doing the work? So I don't know whether that's true or not, but it's something we got to think about.
Yeah. I don't know whether that's true or not in the case of the landscaper you talked to, but I do know that it's possible to get these devices that work for a full day on a charge without having to be, without having to be recharged. So it may require purchase of additional batteries. Sometimes, that's the case, but I don't think that I don't know in every instance, but I know that you can do that. You can operate this equipment without having to go and get a gas powered truck to charge them up. So again, I can't speak to that specific situation, but and again, this equipment gets better and better as the technology improves. And hopefully by 2030, we'll be at a point where this equipment is much more efficient. I mean, if you look at cars and the evolution of electric cars, they've gotten better and better and better. And this equipment is going in that direction. And the only other thing I would say is, again, I go back to the Montgomery County Parks and Planning. They are very proud of the fact that they're all electric and they use electric for all of their jobs in all of the parks and recreation areas in Montgomery County. So, I know that's maybe not applicable across the state, but it is, again, it's a start. Thank you.
Delegate Martinez.
Thank you, Madam Chair. And appreciate my colleague from the Eastern Shore backing up our lawn workers and folks. Is glad that we both have that concern. So I won't ask questions about particularly the contractors. We'll wait for subcommittee for that. But I did have a question around approach. You mentioned how Colorado kind of was giving an incentive. Why wasn't necessarily that the thought process brought to this process? And I think too, something that we need to remind ourselves is that intent and impact are two very separate things. I think there's great intentions behind this, but I think the impact still needs to be massaged through.
Yeah. So this is a bill for state agencies. So we would not incentivize state agencies in the way we would incentivize consumers. So the Colorado situation is a consumer. It's a consumer law. So if I, as a private individual, go to buy a leaf blower, just like if I were to buy an electric car and I get a tax incentive to buy the car, get a rebate on the car, it's the same thing, same idea, right? Go to buy the leaf blower, you get a rebate on the leaf blower. It's actually a tax credit, but it's a tax credit at point of sale. That's what they do in Colorado. Why am I not considering that here? One, it's a state agency. Two, our fiscal situation is such that I don't think we can be offering at this point in time tax rebates. But it's something I'm going to look at in the future.
Go ahead.
I just think that if we're going to put burdens on business, we should be mindful of what those impacts actually are, particularly for the disenfranchised communities that I represent. It's already hard to get a slice of the pie in terms of these state agency contracts. So my question wasn't about the state agencies in the context of your bill, but just the stick versus carrot approach. But I look forward to seeing this in subcommittee. Thank you.
Thank you.
Thank you.
I don't see any other questions for these two witnesses, so I'm going to move on to the next witnesses that are virtual, please. And just for the record, I would like to address that DLS, the Department of Legislative Services, does comply with the ADA. They offer accommodations and interpreting services, and the information is on the website. In addition, there's an ADA coordinator for the General Assembly. Her number is 410-946-5400, toll-free number 1-800-492-7122. In addition, the MGA has a website on accessibility, complying with ADA. In addition, the YouTube channel, if you go to the CC, you enable it, you're able to see it. And finally, this committee deals with a lot of people that have disabilities, and we pride ourselves in making accommodations for the people that testify here all the time. Thank you very much. Just wanted to clarify the record. May we go next, please, to the virtual witness? Actually, Emily's here. Yes, hi, Emily.
Oh.
Thank you.
Sorry if you called me earlier.
No, I did not.
Okay.
How are you?
I'm good. How are you? Nice to
We're
see you.
doing well. Go
Good to be
ahead and
here.
get started. Thank you so much.
My name is Emily Scar. I'm the director of Maryland PIRG here in support of HB 91. Maryland PIRG is a state-based, small donor-funded public interest advocacy organization with grassroots members across the state. Our mission is to find common ground around common sense solutions that help make our world healthier, safer, and a more secure future. So the delegates talked about our report already, and I think this is a good modest step to start the state to phasing out the use of fossil fuel lawn equipment. I wanted to highlight a couple of things since you all have had a robust conversation already. We released a report. I sent the executive summary in my testimony. When my colleagues in Colorado started working on this, I was like, oh, lawn, leaf blowers, all right, whatever. But then I saw it's just an astonishing amount of pollution that is created by these gas-powered lawn equipment. I think using some gas-powered equipment for 1 hour is the same as driving a car for 90 miles. And I think that's what we need to keep in our mind. We can talk about reducing climate emissions, et cetera. Just like the amount of air pollution we're spewing right in our front yards where our kids are playing, where we're walking around is outrageous. And we should be taking measures as a state to try to reduce it because the electric options out there are great. I have them for my home. And the commercial options are getting better. I think in all our report talks about all the different things. I think chainsaws are the one part of the market where they still need some work. But generally speaking, the options are ready and they're available and they work. Yes, as the delegate said, there are some upfront costs, but there's long-term savings, not to mention our health savings and our climate savings. The amount of maintenance required for electric equipment, just like we have for electric cars, is just so much lower. You don't need to pay for gas. Yes, you might need to buy an extra battery if you're using it for commercial purposes. And yes, we should explore incentives to help our landscapers switch over to make sure there's, an equity perspective when we're talking about larger reforms. But for this bill, where the state is just taking the lead, makes a lot of sense to me.
Are there any questions for this one witness here? Seeing none, thank you. May we go to the virtual, please? And thank you very much for your testimony.
Sure.
We have two people virtually. Diana, how are you, Ms. Conway? Nice to see you.
Thank you. Thank you. Nice to see you.
And Happy New Year to you.
Thank you. Thank you. And to you and the committee. Am I on? Am I the
Yes,
first one
you're
up?
on right now.
Great.
Yes.
Thank you. So good afternoon, Chair Pena-Melnick, Vice Chair Cullison, and distinguished members of the committee. I'm Diana Conway, and I'm here on behalf of the Montgomery County Women's Democratic Club. WDC is one of the largest and most active Democratic clubs in Maryland, with hundreds of politically active women and men, including many elected officials. And I'm here to support HB 91 on behalf of WDC. It's a positive step for human health, for worker safety, for environmental protection, and really for the coherence of our climate strategy. So WDC thanks Delegate Foley for bringing it forward and for your work with the amendments. The bill takes a dangerous polluting class of products and charts a reasonable path to their replacement with electric powered equipment. And this equipment is so ubiquitous, everyone is exposed over and over to the air and noise pollution, especially the workers, the frontline workers. They're among the dirtiest burners of fossil fuel, especially the two-stroke engines. So we need this bill because we need to grab the low-hanging fruit on climate change. There are no perfect solutions, and children have been working in China doing lots of things other than just possibly pulling out lithium. In this case, the market transitions to electric is well underway and accelerating. We can simultaneously benefit from the newer, cleaner equipment that's commercially available and support the further growth of these industries. So the state and its contractors get a reasonable transition window. Marylanders get quieter neighborhoods and cleaner air. We get safer workers. And the bill means fewer points of fossil fuel use and one more piece in getting to the climate pollution reduction plan and the goals of the Climate Pathways Report. The fact that all this pollution and toxicity and heat and noise goes into maintaining lawns and gardens and landscaping makes this bill all the more important. Addressing climate change is really hard. It's going to get harder. So let's at least knock out the easy stuff where there are available practical options now. Maryland can really continue to be a climate leader. So please vote for HB 91. Thanks.
Thank you. Are there any questions? Seeing none, thank you so much, Ms. Conway, for your testimony today and for what you do for the community. Next, we have someone from the Sierra Club.
Good afternoon, Chairwoman Pena Melnick and members of the committee. My name is Marie Laporte, and I'm speaking on behalf of the Maryland chapter of the Sierra Club and its 70,000 members and supporters in support of HB 91. Across the U.S., turf grass is by far the largest crop and occupies about 3 times the acreage of corn. So the impact of management is considerable. While often overlooked, gas-powered lawn equipment is surprisingly significant as a source of air pollution and greenhouse gas emissions. After extensive study, California determined that gas-powered lawn equipment is a greater source of smog-forming emissions than all the cars in the state. In fact, gas-powered lawn equipment in California is expected to contribute double the emissions of their 14 million passenger cars by 2031. That is particularly stunning when one considers that only 4% of California is turf grass, according to NASA satellite imaging, while Maryland has about 20% of our state covered in turf grass, which requires continual maintenance, typically noisy, gassy, and polluting. And I do want to correct, Emily mentioned that gas-powered leaf blower for 1 hour produces as much pollution. It actually is a Camry driving 1,100 miles. So 1 hour of a gas leaf blower is about the same as driving a Camry for 20 hours and 55 miles per hour. According to that PERG study that they did, thank you, based on EPA data, concluded that gas-powered lawn equipment in Maryland annually creates as much PM 2.5, a measure of air pollution, as 6.4 million cars, 3 times the number of cars registered in Maryland. If we're committed to improving Maryland air quality and addressing the climate crisis, we must look at these polluters. This bill is both consistent with the goals of the Climate Solutions Act now and aligns with our climate reduction bill. We hope you will give a favorable review to HB 91 so that the state will set a good example in its management of its lands and facilities. Thank you.
Thank you. Are there any questions? Seeing none, thank you so much for your testimony today and for coming. We really appreciate it. Now we're going to go on to an unfavorable panel. Thank you, Delegate. Thank you very much. You can sit in the audience. We're going to call an unfavorable panel.
Okay.
So next we have Ms. Nicole Sherry, Brandon Sams, and John Murphy. Will you, all 3 of you please come up and provide your testimony? Good afternoon, and thank you for your patience. And Delegate, I know you're waiting. Your bill is next. We really appreciate your patience. Good afternoon. Who would like to get started?
I'll start.
Thank you.
Good afternoon.
Good afternoon.
Madam Chairman, Madam Vice Chairman, and members of the committee. My name is Brandon Sands, and I'm here representing the Maryland Turf Grass Council, otherwise known as MTC. I'm the current president, and I've been in the turf industry for 30 years. Maryland Turf Grass Council represents all areas of turf industry, including golf, sports, turf, sod producers, lawn and landscape, commercial vendors, and suppliers. We are here to oppose House Bill 91 and its prohibitions. MTC and the Mid-Atlantic Sports Field Managers Association, MASFMA, have submitted a joint letter in opposition. For the purpose of my testimony today, I would like to prefer the economic concerns this bill would have on the industry, specifically to locally based companies seeking to do business with and within the state of Maryland. For many local-based landscape businesses, this provision will not only create financial hardship, but it will also significantly reduce competitively viability in the state's procurement marketplace. Companies that would typically compete for state contracts would be disqualified from bidding due to these new prohibitions, therefore resulting in a drastic undercut of competition to only a selected few that have the financial resources to meet this bill's new mandate. The cost of the equipment and the added infrastructure will result in many companies selling their business to larger national commercial operators who can afford to absorb these costs and overhead expenditures, or ultimately they will go bankrupt. Alternatively, their other option will be to increase their prices rates to their other customers and clients that they service to offset the cost of the new batteries and equipment in order to compete for existing or future business relations with the state. Ultimately, these increases in overhead costs conflated with inflation will likely result in Maryland-based companies losing business with state and non-state customers. For the state, the result will likely be a reduction in the turnaround time for the contractors to get the projects completed, as well as experience an increased wait time between jobs, as it takes longer to complete jobs with electric powered equipment, with charge times for commercial equipment taking longer. The options for keeping production time reasonable may result in two options. Option one is buying more batteries, which adds to upfront cost, or option two, which is to use gas powered generator to charge the batteries between jobs, which goes against what this bill is attempting to do. It is for these reasons that the Maryland Turfgrass Council urges this committee to give an unfavorable report to HB 91. Thank you.
Thank you for your testimony. Next, please.
Good afternoon, Chairwoman Pina Melnick, Vice Chairwoman Collison, and members of the Health and Government Operations Committee. For the record, my name is Nicole Sherry. I am the past president of the Mid-Atlantic Sports Field Managers Association and current head groundskeeper for the Baltimore Orioles. The Mid-Atlantic Sports Field Management Association is a nonprofit organization which is composed of sports field managers and workers from Maryland, Delaware, Washington, D.C., and Northern Virginia. As MASFA members, we partner together to promote education, teamworking, networking, and best management practices among our peers within the sports turf industry. We also oppose this legislation and echo the same concerns addressed by Mr. Sands from the Maryland Turfgrass Council. For the purposes of my testimony today, I would caution this committee to pass such a legislation at this time. While we support the advancements in new and emerging green electric technologies for the industry to use, these technologies are still embattled with matching the same level of service production and costs when compared gas-powered alternatives. More importantly, there are still environmental concerns that have yet to be resolved that are just as concerning, if not more. The batteries from electric equipment are both costly to make, and there's no real disposal system in place for all the batteries once they reach their shelf life. And while this legislation is laudably attempting to reduce the state's carbon footprint, based reducing and eventually phasing out gas-powered lawn equipment, this bill fails to recognize and address the most obvious environmental concerns, the battery itself. Outside of putting them in a landfill, which can lead to cracking, leaking, resulting in potential groundwater contamination, there are no other current environmentally sound alternatives, recommendations, or regulations by Maryland to safely recycle the batteries. It is for all these reasons that we urge this committee to give House Bill 91 an unfavorable report. Thank you, and I'm here to answer any questions.
Thank you. Next, please.
Thank you. I'm John Murphy. I'm the chairman of MAGIC, the Maryland Green Industry Council. I'm also a MDA agricultural commissioner to the nursery trade. I'm a MDA representative to the State Soil Conservation Committee, past president of the Maryland Nursery Landscape Greenhouse Growers Association. My advice would be for Delegate Foley and her team to reach out to the #2 industry in the state of Maryland, the nursery trade, the nursery landscape trade. We have utilized a lot of sustainable energy. I can give some examples if you ask where. And we are striving for a sustainable energy, not just electric, but solar power. We can set up a Zoom call where you can talk to the people, the members of our industry from the Maryland Nursery Landscape Greenhouse Growers Association, Maryland Arborists Association, the Maryland Association of Green Industries, and the Frederick Area Landscape Contractors Association. Very large group of people, professionals. We know what we're doing. We care about the environment. We are the stewards. We can help bring these emissions down. The benefit of talking to the people in the associations that manage these lands will be greatly advanced what we're trying to do here in the state of Maryland. I'm open for questions.
And thank you for your testimony. First, I have Delegate Hutchinson.
To the gentleman that just spoke, could you elaborate on some of those examples that you said that you have?
I'll give you some examples I use on my own 2.5 acre facility on the Eastern Shore of Maryland. I'm an annual, perennial, and native plant grower. We use solar powered battery chargers. We use solar powered fencing to keep the deer out of our hemp and other produce we use in the fields. And I use more than 90% of my watering on my farm is used by solar powered watering booms. I invented my own watering boom. It was manual. It's now working on solar power. These are just an example of some of the things we are using in my trade in greenhouse alone. And we use battery powered blowers in our greenhouse. We do not use the other, only because battery powered blowers would take the debris out of our greenhouses, so we have less habitat for invasive insects to live in, and it's just a light amount of debris, so the battery powered blowers work very efficiently. But when you have a heavy leaf buildup on some of these commercial sites, what's out there will not blow them. I used to be in a trade myself, as Delegate Hutchinson as well. If this isn't accomplished under this bill, if it's not accomplished, we can't get these heavy leaves off. We're going to have other issues such as termites. We have termite problems here in the state of Maryland. When you have wet debris coming up on the foundations of some of these buildings, that gives an avenue for the termites to come up. Now we have to use more pesticides. So this can create a little bit of chaos if it's not done properly. And this is why I suggest we talk to professionals that's out there in the field doing this work. Thank you.
Next, I have Delegate Chisholm.
Thank you, Madam Chair. And I would have been severely disappointed if Delegate Rosenberg did not push his button to ask Ms. Sherry a question.
He's coming after you.
I know. Isn't it true that Major League Baseball has been around for 118, 120 years, and you're only one of 2 female groundskeepers in all of Major
in
League?
history, in history.
So it's safe to say that you have a great deal of knowledge.
Yes.
So thank you for your testimony. So I just wanted, isn't it so that she has a great deal of knowledge in this subject? Thank you, Madam Chair.
Can I respond or?
Take the
Thank
cup. Go ahead. Go ahead.
Okay, thank you. First of all, it's lovely to see people that look surrounding me. So thank you, women, for that. Yes, we are all for pushing towards, better practices for sustainable equipment. However, there's a lot of work to be done. These pieces of equipment, like my counterparts have said, just don't have the bulldog behind them to get a lot of these jobs done in a efficient amount of time. And then just the labor shortage, as one of the delegates mentioned already. This can really affect our industry as a whole: landscape, sports turf, field managers, everybody that really has to be in the labor force with this industry.
Thank you. Delegate Rosenberg, followed by Delegate Hill.
My question has to do with the care of a certain state facility. When I was there in the warehouse for the announcement about the lease, I looked out on the field, and pitcher's mound and home plate were covered.
Yes.
But not the infield. So my question is, why are they, presumably, are they covered at all times, and why?
Okay, so yes, they are covered at all times because the pitcher's mound and the batter's box is made up of 100% clay, and the infield dirt is a mixture of clay, silt, and sand. So that can freeze and thaw a little bit easier with the elements versus the clay on the pitcher's mound. If that dries out, it's a lot of work and a lot of effort to get that back in shape for our Baltimore Oriole players.
Delegate Hill, followed by Delegate Riley.
Madam Chair, and
My
thank-
pleasure.
Thank you all for being here. I want to address this question to the first gentleman. I'm hearing you and you're saying that it sounds like an easy thing to just replace equipment. But the part of the bill I think you're actually objecting to is the one that says the state can't contract with a contractor who by 2025 haven't removed all this equipment. And so the question is there a date that you would think would be reasonable, 10 years, 12 years, 7 years, that if we wanted to really move forward in terms of what the state does and prohibiting, our using this kind of equipment, is there a time frame that might make sense? I mean, recognizing that small businesses sometimes keep equipment like I keep my car for 10, 12, 11
Right.
years.
I mean, from a personal standpoint, from an organizational standpoint, we want to see the technology now. If we could put our hands on it right now, we would not be as opposed to this bill. And if the cost of this technology was down a little bit, we wouldn't be as opposed, because my section of this will cover cost effectiveness of it. So I would love 10 years from now, maybe this bill could be put in effect, because the industry can't keep up with it right now. I do it for a living. I run a crew right now that, I have 50 employees that run equipment every day of every day. So it's not only the cost of equipment, but the batteries also weigh more than gas-powered equipment. You're talking about the wear and tear on people's lives. I've put on a backpack blower. I've purchased backpack blowers that are battery powered, and they're also louder. They're not quieter. They're actually, by OSHA standards, they're louder than a gas-powered blower, because the industry is trying to keep up. So to make a commercial grade piece of equipment, they have to keep up with the power. And to add more power, they're adding more battery, which is more lithium, which is coming out of the ground, which is mined. So these are all the things that the industry is not there yet. We want to see it to be there, but it's not. And it takes longer because you're powering batteries. You actually physically have to, like a Tesla can't drive to Florida on one charge. Same like a battery powered blower. You're not going to do a job in one day. You're going to have to carry multiple batteries. It's not the piece of equipment that costs the money, it's the batteries. Batteries can cost $700 up to $5,000, depending on what kind of equipment you're buying. Or a $300 backpack blower now is costing you $1,500, and you have to buy a $500 charger, and you have to have multiple batteries. Think of that from an economical standpoint. It's not there yet. So we want to see this happen. Realistically, maybe 10 years from now, as the battery manufacturers and the equipment manufacturers catch up with the commercial side of it. I own battery powered equipment myself at home. It's easier and it's economical, but it's not practical. It's not practical from a commercial standpoint, which we're arguing here today, because it's not there yet. And we want to see it there. So maybe 10 years from now, it'll be there. But in my mind, that means you have to make a bigger battery and a heavier battery and a more expensive battery. And is that going to solve the issues? I don't know yet.
Delegate Riley.
Thank you, Madam Chair, and thanks to the entire panel. You've probably given us more information than some of the things that we already knew that I personally did not like about the bill, and have given me more reasons to not like the bill. But anyway, we talked about, we had a lot of discussion on the batteries, and we saw, how it's probably not ready for that. And the whole purpose for the bill, I think, was to make an environmental safe, and, the Climate Solutions Act now. But everything that I'm hearing, the batteries, they do a lot of damage to the environment, and that we just don't have enough information. So that we've determined. So the sponsor of the bill had mentioned, okay, well, not everything's going to be done by battery. It's going to be done by electric. Okay, so are you familiar with like the PJM or our energy resources, whether it's Constellation, BG&E, Delmarva, and the report that they just gave that said that they're very, very concerned about, our climate change and the bills that we just currently, are moving forward with, and maybe, too fast of a manner, because our electric grid we're not there yet even with the electric. So we have the problem with the batteries and what that's going to do to the environment and the quickness that we're moving. So your thoughts on like the grid with the electric. So if you can't use the batteries, then you got to use the electric. And then we mentioned the two large
Sorry. Can I have a second? on that?
Can you let him answer the
Okay,
first question?
yes.
Thank you.
Who is it directed to?
Any of us.
Someone second.
Where was the best person to do it?
Which, repeat the question again.
The electric grid in the back.
The electric grid, I'm sorry. I was
Capacity.
thinking about DC actually uses a truck using diesel fuel behind the team with the blowers. So it is being done in DC, but there's as much emissions going out of that diesel truck. But as far as your specific question, this guy would know better than I.
Well, now it was basically, we're gonna ask the question to one person because it's already 3:30 and we have one more bill. So the best person can answer. She was asking about the capacity of the grid.
I mean, we don't really have numbers on what it would do for the capacity of the grid, but obviously it's going to put a lot of strain on our electrical grid pretty much in every county.
Okay, you have another question?
What was,
Yes.
you know, the two agencies that will be actually impacted by this bill are MDOT and DNR. Do you think they're ready to, you know, go fully electric or pattern?
So just a quick talking point, and I know Delegate Foley mentioned that this isn't going to affect a lot of the bigger landscaping equipment at this point in time, but electric mowers must be used on shorter grasses or they'll get bogged down and drain the battery. Electric mowers will increase mowing frequencies, which goes against the established MDOT SHA turf grass guidelines. The increased frequencies will cause state mowing contracts to double or triple in cost.
All right, and the final question is Delegate Bagnall.
Thank you, Madam Chair, and thank you for being here. I know we've been talking a lot about environmental impact, but I want to go back to the issue of health, because one of our panelists talked about the health and well-being of the workers who are being impacted by these emissions. And those concerns are very real. So can you speak to whoever is best to speak on this about how you currently protect workers, or do you see potential health benefits as the industry transitions to electric, so workers aren't actually being impacted by these emissions?
Who's the best person for that?
I mean, obviously, if you're not running gas-powered equipment, you're not breathing in the air. I mean, that's the whole goal we're trying to get to. But the other impacts, you still have to wear hearing protection, which goes for OSHA guidelines. You know, basically everything that my staff has to go by is by OSHA guidelines, whether they're boots from their hat to the hard hats. And I do know of the batteries that have exploded have actually, I don't know if they've killed individuals, but they've actually caught people on fire. Like back in the day when you heard cell phones catching on fire, this is a real problem because they're trying to get the technology there. And power means a lot of electricity going through one little tiny battery. And I've been in the industry. I've heard of at least 6 different cases across the country where the battery has actually exploded and caught fire. So if you can think of your local landscape company blowing your backyard, and what would you do if you see the battery blow up and you're now person that you hired is caught on fire from a battery? Nobody wants to see that. Nobody wants to hear about that. But those are the realities because the technology is not there and they're trying to catch up with the technology. And until that gets there, the safety standards are going to be the same whether you're running gas or electric. And it's all based on OSHA standards. I don't even think OSHA standards have caught up with the industry from a commercial standpoint yet either.
Okay. See no other questions. Thank you for your testimony and for the work you do in our state of Maryland. This actually concludes the bill hearing on House Bill 91. Next, we have the last bill of the day, House Bill 133, Commission to Study African American Civil War Soldiers in Maryland. Good afternoon. I want to thank you for your patience. It was a long hearing, so thank you very much for being patient, okay?
Well, since we were talking baseball, I feel like to clean up batter. And serving on judiciary, I'm used to these long afternoons. And the one day I find out Chairman Clippinger lets everyone out early, I still find myself in a committee. But such is life. We're here because we love it. Thank you, Madam Chair and Madam Vice Chair and honorable colleagues. For the record, I am Christopher Eric Boucher, and it is with tremendous honor that I present HB 133. After the Emancipation Proclamation of January 1st, 1863, African Americans were allowed to join the United States military. 180,000 brave souls stepped up and heroically served, 10,000 from Maryland and 6 regiments. Those men were either former slaves who escaped to Maryland across the Potomac River, freedmen from Maryland, which had the largest freedmen population of any state, or Maryland slaves sold into the army to obtain their freedom. Imagine being one of these faced with the possibility you could be captured, tortured, executed, or enslaved again. Would you have the courage to do as they did? My research concluded that Maryland erected 32 Confederate monuments to the traitors of our nation and only 4 to the biggest patriots of the war, African-American soldiers. Their additional manpower was the decisive element that broke the defenses of Richmond and Petersburg, sending the Army of Northern Virginia fleeing to its ultimate defeat at Appomattox Courthouse. It is fitting that this institution, which is with the largest number of African-American legislators and a governor, moved this bill and addressed 159 years of racist injustice through the intentional ignorance of their contribution to the cause. Never before have we had the opportunity to research, capture, record, and disseminate in historical texts their story to share with future generations. I predict that this will be like peeling open an onion. A wealth of awe-inspiring stories never before made public will be discovered. The data can be used for educational curriculum, maybe even a booklet on the subject, as was done on Maryland slaves by the State Archives Department. I envision a future where African-American students can not only read about their heroic ancestors' duties to save our nation and end slavery, but also to be able to visit the awe-inspiring battlefields where they served and sacrificed. Maybe one day a website of this data can be made to share their story and even allow people to research the soldiers' names and discover they are direct descendants. With that said, I will turn it over to the professionals of this panel. First, my beloved constituent, Mr. Richard Turner. Thank you.
Next, please.
Honorable Chair Pena Melnick, Vice Chair Cullison, and members of the committee. I'm Richard Turner. I'm a Maryland resident. I come before you. I speak in favor of the intent of HB 133 with amendments. I'm before you as an individual, not as a representative of the various organizations with which I am associated. I will summarize my testimony. I'm not a historian or a researcher, but come from a family that appreciates the importance of understanding history and working to expand those works to include the contributions of those whose efforts have gone unrecorded and often forgotten. My father was a World War II era Buffalo soldier. I was stunned when I went to the Encyclopedia Britannica, and among the many references to other stories of war, I could find none for the Army's 92nd and 93rd Division. In a quest to find out more about my family's roots in Kentucky, the family discovered that we had 3 great-great-grandfathers born into slavery who ultimately served in the Civil War to end slavery. Living and working in Carroll County, I became aware of Ellsworth Cemetery, whose founders included slave descendants, Civil War veterans. The subsequent history, including neglect, desecration, and now heroic efforts to restore the cemetery, are significant in healing such prior disregard. A memorial is but one step that can be made and should be taken to recognize the service, sacrifice, and honor these veterans deserve. My hope is that the legislation would expand the scope of the proposed commission to, rather than a single memorial, would consider memorials as a plural. The research envisioned and already accomplished should include sailors and recommend other recognitions such as landmarks, wayfinding, interpretive placards, etc. I sincerely hope that this bill works as it works its way towards adoption, that it will incorporate, build upon, and facilitate collaboration among the efforts of others in Maryland who have been doing the time-honored work of recognizing those who have served, sacrificed, and brought our nation to a more perfect union. My thanks to the bill sponsors and co-sponsors for bringing this opportunity in for consideration and this opportunity to testify.
Thank you for your testimony, and you were so timely. Thank you so much. Next, please.
Good afternoon, and thank you for this opportunity to testify in favor of House Bill 133. My name is Elizabeth Chateau, and I am the Executive Director of the Heart of the Civil War Heritage Area, serving heritage tourism in Carroll, Frederick, and Washington counties. Ours is one of 13 heritage areas certified by the Maryland Heritage Areas Authority. My organization would be pleased to have a place on the proposed commission. The commission work is relevant to our purpose. Our mission statement makes it clear that with our partners, the Heart of the Civil War Heritage Area preserves and promotes diverse stories in our counties. The proposed commission aligns with our strategic plan, which sets forth foundational principles for interpretation to guide our decisions regarding historical research and storytelling. Briefly, they are: the Civil War is unfinished business. Complexity is interesting. And if we don't know the stories, we can't share them. House Bill 133 anticipates a future tourism product, a memorial that will add to the range of visitor experiences that serve our residents and draw travelers to the state. In this way, the work of the proposed commission will contribute to the economic impact of tourism and help establish Maryland as a place that is responsive to changes in demographics and emerging trends in the tourism market. We recognize that the timeline for a commission report is ambitious. We also encourage expansion of the scope to include both soldiers and sailors, but that would, of course, add to the timeline challenge. These concerns do not diminish our support for House Bill 133. We welcome robust discussion and hope for your favorable consideration. Thank you.
Thank you for being here. Next, please.
Good afternoon, Madam Chair, delegates. I am Cheryl Renee Gooch, Civil War historian and executive director of the African American Resources Cultural and Heritage Society, also called ARCH Society of Frederick County. ARCH Society chronicles, researches, and interprets African American life and history in Frederick County, including the documented enlistment of more than 400 men from Frederick County who served in what was called the United States Colored Troops, regiments that were formed here in Maryland, Pennsylvania, and Massachusetts, as well as Virginia, excuse me. These men's military roles transformed them into agents of emancipation. An active partner of the Heart of the Civil War Heritage Area, ARCH Society, supports this bill to establish the Commission to Study African American Civil War Soldiers in Maryland, to recognize and honor those who sacrificed to reunify our country and liberate 4 million Americans held in bondage. More than 8,000 African Americans in Maryland served and responded to President Abraham Lincoln's January 1st, 1863 Emancipation Proclamation that ordered the formation of what became the United States Colored Troops. 6 African American Maryland soldiers, colleagues, received the Medal of Honor, our country's highest award for military valor and action. Private Barnes, St. Mary's County. Landsman Brown, St. Mary's County. Cater Dorsey, Howard County. Sergeant Major Christian Fleetwood, Baltimore County. Sergeant Harris, St. Mary's County. Sergeant Hilton, Hartford County. Arch Society wholeheartedly endorses Bill 133 to honor those men who reunified our country under one flag. Thank you.
Thank you. And thank you for the work you do. We do have another person in person, Nicholas Redding. Will you be so kind and just pull up another chair, please? Well, friends here. Yes.
Scoot down here. We'll make room.
All righty.
Thank you for being accommodating.
Of course. Glad to be the last.
Go ahead.
My name is Nicholas Redding. I'm the president and CEO of Preservation Maryland, which is the statewide nonprofit preservation group, and I'm here to offer our organization's emphatic support of the legislation. As you heard previously, there were 6 names mentioned, and they're worth mentioning again. William Barnes, William Brown, Decatur Dorsey, Christian Fleetwood, James Harris, and Alfred Hilton. And these are names that everyone in Maryland should know, but we don't. But they're synonymous with bravery, heroism, and true patriotism. They're the names of African-American men who earned the nation's highest military decoration, the Medal of Honor, during the American Civil War. These 6, however, as you've heard, comprise just a small fraction of the over 10,000 African-American men from Maryland who served, all of whom deserve their stories to be told, honored, and commemorated. And those 10,000 from Maryland are just an Army Corps' worth of nearly 200,000 who served from across the nation, staggering 10% of the Union Army that worked to put down the slaveholders' rebellion. Maryland's own Frederick Douglass powerfully explained, "Once let the black man get upon his person the brass letter, U.S., let him get an eagle on his button and a musket on his shoulder and bullets in his pocket. There is no power on this earth that can deny he has earned the right to citizenship." It has long been since time for this state to study, honor, and celebrate the service of these defenders of democracy. Because, to paraphrase Emerson, when duty whispered, "Lo, thou must," Black Marylanders replied, "I can." We have missed the opportunity to shake their hands, to host them in the state house that they kept safe, or to invite them to a dedication to a monument in their honor. But by providing a favorable report on this bill, we can do the necessary work to ensure our own generation does not repeat the mistake of overlooking their invaluable service. And so I'd encourage this committee to raise a standard to which the rest of the nation can follow and create this commission to show how the Republic was saved by these stalwarts of liberty.
Thank you. Thank you for your work. And we have Ms. Clara Small testifying virtually. Ms. Small, thank you for your patience. Will you be so kind and get started?
Good afternoon, Madam Chair
afternoon.
and Madam Vice Chair and members of the Health and Government Operation Committee. My name is Dr. Clara L. Small. I'm Emeritus Professor of Salisbury University. I support this bill because it is designed to help preserve a sizable part of our state and nation's history, not just for Americans of African descent, but for everyone. This information is also important because Americans of African descent have served in every war and every conflict and skirmish this nation has been involved in, even before it was the United States of America. This information should also help this research should also help dispel the belief that Blacks have never done anything in this country. Hopefully, all of this information should be taught in the schools and everywhere because our state and nation's history is actually a mosaic. To deny this history is to deny the fact that it is important, as well as an important part of local, state, and national history. We should, hopefully, Maryland will not allow that to happen because this history is important. It should not become a mockery of our educational system, as has happened in some states. We must teach this information to everyone. This is so important because we must put flesh on the bones of those individuals who served in the USCT, their names, their age, their rank, their height, their complexion, eye color, hair color, distinguishing marks, and if they were slaves, who their owners were, and the fact that they received $300 for each of those slaves that served. This must be done. Otherwise, we will not have a history that should be important. We should not fall into the category of what Dick Gregory once said. A man without knowledge of his history is like a tree without roots. And we know that tree without roots cannot stand, survive, nor thrive. This history is important. Thank you.
Thank you, Dr. Small, for your testimony. Really appreciate you. Are there any questions for this panel or Dr. Small? Oh, 1 second. Delegate Lewis, followed by Delegate Alston.
Thank you, Madam Chair. Colleagues, I know it's late and we've heard a lot of bills today, but I really want to thank the good delegate for being a good human and bringing this bill. I want to thank you for your panel. Outstanding, stunning, make me really proud to be a Marylander alongside with you guys, even though I wasn't born here. I'm here now.
Me either.
Thank you, Madam Chair, for your indulgence. My question has to do with whether or not other states have created similar commissions, if you're aware.
I am not aware of, and usually bill drafting checks, and they never came back with any reference material of any other state that I know of. So this could be revolutionary and set their standards for other states. Maryland is not the only border state that had slavery but did not succeed. The state of Kentucky and Missouri did the same thing. So they could potentially follow suit with the template that we set forward. This has the supporting letter from the NAACP, so they don't pay attention to this. And through them, I hope that this can spread. Like I said, this is 159 years of injustice. It needs to end, and future generations need to know the sacrifice that put us here today. Thank you.
Delegate Alston.
Thank you. I want to say me too. Thank you so much for bringing this bill. It's a great bill. You had a great bill hearing, and I just wanted to get clarity on what the requested amendments were. Was it just to add soldiers?
Sailors.
Sailors and soldiers.
Who's the best person to add sailors?
I believe it's just the addition of sailors.
Thank you very much. Delegate Riley.
Thank you, Madam Chair. Yes, thank you for bringing the bill. It's a wonderful bill. It's an honor to be part of Harford County. I know we have other members here, for the Alfred B. Hilton. We've done many things for him. We have a memorial. We have a statue now, which just, came up, and it's pretty amazing. And the people who run it, we have the foundation, we have fundraisers for it, and it's great. And I love what you're doing. Would it be possible, this, I guess, would be for the sponsor. I believe in the fiscal note, it says that in current law, we have a commission on African-American history and culture, Governor's Commission on Maryland military monuments. Is there any way that maybe we could put your bill into one of those already created commissions, due to the fact that, a commission always costs additional money. We're always in this committee really worried about, the fiscal note, but it would still be your bill, your concept, maybe put on the responsibility of a current commission. I'm just saying, I don't know.
I had consulted with Chris Haley from State Archives, and this seemed to be the root of the professionals at the moment.
If I may, I did bring that up. The delegate met with me privately before the hearing, and I suggested that, and it's not possible. He looked into it.
Thank you,
And he
Madam
followed
Chair.
everything I saw the folder, very impressive. Well done. Well done. Yeah, so he met with me, and I told him that, and he looked and could not, and he did everything, really follow the instructions really well.
I listen and do what I'm told, so thank you, Madam Chair. I want to very quickly address the issue of the United States sailors. Maryland with the Chesapeake Bay had a lot of African-American sailors. Matter of fact, the fact that we had a lot of African-American sailors is the reason Frederick Douglass was able to escape slavery. He dressed and posed as a sailor, and African-American sailors were able to move more freely than most other people. However, under the time frame and constraints, I'm able to move this forward as is because it's fairly narrow. I think that would be a bill for a subsequent year once we dig into this. And the reason being is that would be the Navy, this is the Army. And I think that bill should go to the professionals very closely here in the United States Navy, who could really do a phenomenal job on that and more or less take command of that bill separate from this bill. And African-American sailors can be a very complex thing, because I started looking into this. They would not allow more than, I believe, 5 African-Americans on any vessel because they were scared about a mutiny and a rebellion. They also were not allowed to have any positions of authority. So it's going to be very difficult and time consuming to delve through all those different vessels and all those different sailors. But it is something that will also need to be addressed, because the contribution of African-American sailors is tremendous. The first strategy of Abraham Lincoln to defeat the Confederacy was to close all their ports. It was a naval blockade, and that was made possible by the extra manpower of African-American sailors. So yes, they need to be honored, but next year, I think that'll be a second bill I can propose, since this one seems to be so nuts.
Well, seeing no other questions, Delegate, this bill is going to be assigned to the Government Operations Subcommittee. So make sure that you come and help the discussion. I want to thank all your experts and Dr. Small, who's on virtually, for making time to come and address the committee. We were paying attention. We really care and do not take your time for granted. I hope you have a beautiful evening. Have a blessed evening, okay?
You as well.
For the committee, I want to thank you for your questions. They are consistently for the last, this is the 3 week, have been, as always, very smart and very thoughtful. But I also want to thank you for being so respectful to our witnesses. Sometimes we don't get that respect ourselves, but we give the respect, and that matters. And you set the bar, and I'm so grateful. You have a blessed evening, okay?
May
Take
I
good
add-
care.
May I add something?
Yeah, thank you so much for your. Oh, wait a second. Can you turn it, take us down, please?